Okay, ladies and gentlemen, we're going to call the meeting back to order. Hopefully everybody had a good lunch and a good press conference and got everything done they needed to get done. So we'll try and get moving on this afternoon's agenda. The first thing on the afternoon agenda is we're going to handle old business and new business items. There is no old business, so we have a new business item, which is a discussion by board members on SEBBI 2023-0001, and this is an agenda item placed on the agenda by board member Edward Lindsay, and so he is going to lead our discussion. The floor is yours, board member Lindsay.
Thank you, Tim. And Mr. Rossi, I apologize, but as I was thinking before we came back in here, and with the board's permission, if there's something that you would like to say for a few minutes about the jurisdiction over our jurisdiction over the Secretary of State on this matter, anything you want to add? Yeah, I'm serious. I'm just 4 or 5 minutes, but I think that obviously we've got a group here that's been very interested in the complaint. And I think that in the interest of fairness, that we ought to give you a chance to speak to it publicly for a few minutes.
So that's unanimous. Well, I appreciate the opportunity.
That's a unanimous, what is it? Unanimous motion. Unanimous consent motion. Unanimous consent motion. So is there any objection? Hearing no objection, Mr. Rossi, you have 5 minutes.
Okay, I appreciate the opportunity to speak. I will say I'm not prepared because I didn't know I was going to get to do this.
And I apologize for that.
That's all right.
As I looked at it, Mr. Rossi, let me just say I apologize, but as I was looking at it, as I was walking in, I was going, this is a serious matter. We had several people speak of it earlier, and that, and you've worked very hard on this, and fought very hard for this, and I thought you ought to have a few minutes.
Well, I'll do my best. As Mr. Mashburn knows, I'm not an attorney, right? I'm an engineer. And a funny story, if I may, for a second. I got an invite to brief the board on this matter, and I started calling Miss Alex over there because I thought brief the board meant you come up and meet with them. And her and Mr. Mashburn corrected my non-legal mind and said brief the board means you write something. You don't sit down and meet. So anyways, I'll put it to you in non-legal terms. So all along, as we did this investigation of the errored recounts, both the Fulton County hand audit and what hopefully will become verification of the second machine count errors, Attorney Jack James and I have had in the back of our mind that the errors obviously originated in Fulton County. However, we made it perfectly clear to every person we ever talked to that we can't just point the fingers at Fulton County. There has to be some accountability for the chief election official of the state, who is Mr. Raffensperger. So whether it was, and to be honest, we felt like there was a concerted cover-up effort to protect the Secretary of State's office from any accountability and to send this through to Fulton County, give them a little slap on the wrist, and not do anything to damage the Raffensperger narrative, which was both recounts were perfect. So what are you arguing about? Because they're not. So whether it was Miss McGowan's unsolicited phone call to Jack James after she couldn't deny the errors after Governor Kemp's letter came out of the clear blue, basically trying to strong-arm him and telling he and I to back off the Secretary of State, stay focused on Fulton County. Number one. Number two, shortly after that, in December of the same year, when I was meeting with the investigators on the hand audit errors, it was a good meeting, it was a long meeting. It became obvious to me that they were not independent. And at the beginning, I asked them, I said, how do you guys ensure Jack and I that you're independent? And Mr. Braun, who was with him, and this is a transcribed meeting, so you can all listen to my words and their words. Mr. Braun said, we're independent even though we work for the Secretary of State, and we will go wherever the data leads. So about 2 or 3 hours into the meeting, it became obvious that Mr. Zagorin was getting frustrated because he couldn't convince me that there weren't errors, because I knew there were. I studied them, for months, double, triple counts. I didn't bring that poster. I should have brought that today. But he finally, just so frustrated, made this comment. He said, so Mr. Rossi, you think just because these errors are posted on our, I'm not an English major, but when you say our, O-U-R, you're referring to us. Posted on our website, keep in mind they're independent, and just because they're posted on our website does not make it our responsibility. So right at that point I knew, okay, Ms. McGowan, now the Secretary of State's trying to protect his position. And then came the board meeting, and I'm going to do this cautiously with Mr. Mashburn, but I have learned some things since then, Matt. When I went to that meeting knowing that the errors were created in Fulton County, but I also felt very uncomfortable with the way the Secretary of State's office handled these audits. I gave them the opportunity after that hearing in December. I said, why don't you just go back and ask the Secretary of State to simply put a footnote on that report and say, the governor's team has found this report to have errors. You owe that to the public, and just say you're investigating it. That's simple honesty, and they refused to do that. So in that meeting on the 16th, I was determined to bring up all my emails that I had between myself, McGowan, Sterling, because I wanted the public and the board to know that this is Fulton County originated errors, but we're not going to fix the problem unless we hold the Secretary of State accountable. And in that meeting, I was mad at Mr. Mashburn, to say the least, because he said, every time I brought it up, he said, you're out of order, you're out of order, you're out of order. I had many people call me after that and say, how did you feel like you were treated? And I said, I felt like I was disrespected. Since then, I kind of half understand what Matt did, so I'll give him kind of the benefit of the doubt, but I still wish I would have had the chance to bring up the Secretary of State. So since then, as a lawyer, he has corrected me as an engineer that he gets the cases, and Alex sent me the case sheet. You get a case sheet, and when it comes to the board, it checks who is the respondent. So somebody, I don't know who, at the AG's office, the Secretary of State's office, or the SEB office, checked Fulton County only. So he basically did what that case sheet said. Now, I don't know if the board was involved in developing that case sheet or whether it came directly from the Secretary of State. So I kind of half understand why it was shut down a year later. So after that meeting, I decided with Jack, in a sloppy way, it's not a very professional document, I apologize for that, we filed a complaint directly against the Secretary of State for election code violations. And the main one is that when errors are reported to the Secretary of State, which they were in February, they're supposed to do something about it. And they didn't do anything about it. So that case, that complaint was filed March 21st of 21. And there was a lot of confusion on that case as to whether it was tied to 181, was it a real case, was it closed? Judge Duffy and I went back and forth many, many times with, I can't remember who the assistant attorney, I think it was Elizabeth Vaughn from the Attorney General's office. She finally helped us find it, and Mr. Duffy at that time, in July, he didn't tell me he was going to open a case. He told me he was going to take it to the Secretary of State and look into it. He apparently, I'll have my flip chart up here, he apparently opened up a case on an investigation of the Secretary of State for election code violations, only to be shut down by none other than Ms. McGowan, who moved from the Attorney General's office to the Secretary of State's attorney. And he didn't have to send me that email. He didn't have to send me the attachment. He could have sent me an email that said, Mr. Rossi, this case is closed. Look at what Ms. McGowan just said. But, you know, thank goodness something, I got to believe, I've never talked to him since, something went off in his head and said, something is not right here. The Secretary of State is not untouchable. And so he sent me the email with her attachment, says, Mr. Rossi, here's what Ms. McGowan told me. And she basically said, Judge Duffy, I hear that you have asked Sarah, election director, to open up a case filed by Mr. Rossi for the Secretary of State's election code violations regarding the RLA hand audit posted on our website. There's that word "our" again. We don't own it, but it's on our website. And I am letting our investigators know that they will no longer, this case is closed, basically. And then at the end of her email, she said, I trust, Chairman Duffy, I trust that you will let Mr. Rossi know that this case is closed. So again, I spoke earlier, I'm not sure how Judge Duffy took that, but he didn't accept it. And in the body of his email, his last sentence said, we're considering our options regarding this matter. So then I began the communication with the board, Mr. Mashburn. He knew there was a case. He knew what Chairman Judge Duffy had done. And to his credit, he said, hey, you know, we're going to take this seriously. I don't agree on the unlimited time frame because I'm an engineer and I like things done, but I understand sometimes the law does not go like that. But I think that's where we're at today. I'm not asking the board at this point to hear on the merits of the case. I'm asking them to rule that they have the authority to investigate the state election board. Because if they don't rule like that, then the governor doesn't have authority over the Secretary of State's office. He wrote me that night, great letter, but he made it very clear that that is not his lane. He's not the chief election official. So anyways, that's kind of where, yeah.
Inspector General? Did you ever file a complaint with the Inspector General?
No, sir.
Okay, I'm just sort of curious.
I'm a novice to this.
No, I understand.
I wouldn't even know where to begin to file a complaint
I'm just curious.
with the Inspector General.
Thank you, Ms. Rossi. I appreciate it. Thank you.
Okay. Thank you.
Okay, thank you, Mr. Rossi. Just for the purposes of the court reporter who is taking down this, I think at the very end of your remarks, you said that we should investigate the state election board. And I think you meant Secretary of State. So just for the court reporter, I'm going to go ahead and authorize the court reporter to make that change from investigate the state election board to investigate the Secretary of State. Yeah, so she'll take, the court reporter will take care of that. Okay, the other thing is before we get to Mr. Lindsay continuing this discussion, out of a courtesy to our fellow citizens, is Fulton County is here for a case 2021102, and there was a problem with a notice to one of the respondents. The respondent did not get notice of this hearing, so that case is going to be continued to give the respondent notice of a hearing and a chance to be here. So Fulton County is excused. You're welcome to listen to the debate or head off to other things if you wish, but just wanted to let you know that's been continued because one of the respondents didn't get notice. Yes, sir, Mr. Rossi. Sure. Well, let me ask unanimous consent for Mr. Rossi to have another couple of minutes.
Sure.
Without objection, so ordered.
I filed a brief. It's not a very good brief. I thought it was a meeting. I wrote what I did. I looked up the code. I felt comfortable that they had the authority. But there's some very intelligent lawyers that have submitted, I guess you call it an amicus letter, with many, many documents, much information that has been provided to the board. I trust that you all have gotten that basically states that they do have the authority. So thank you for letting me add that last comment.
Thank you.
Certainly.
Thank you, appreciate it.
Okay,
Mr.
Mr.
yeah.
Lindsay has the floor.
Mr. Chairman, and the other folks here today who are interested in this matter. The difficulty in this case is that we have, for instance, a very old Attorney General's opinion from, what, 05 or 06? That says that we don't have jurisdiction over the Secretary of State. I'm just sort of giving you the history here, folks. Look. Hear me out, okay?
This is not a debate.
I understand.
Mr. Lindsay has the floor.
And we have that, and I've read the other opinions as well, and we've asked for additional updated opinions, and so far we haven't received them yet. And therein lies the difficulty, is first trying to decide if we have jurisdiction over this matter. At the end of the day, though, I come down to this fact when I start considering whether or not we either have or we should have jurisdiction. We have jurisdiction over 159 election boards. We have as well as their supervisors. We have jurisdiction over literally thousands of part-time and full-time election officials, as you guys have heard in the various hearings today. We have jurisdiction over 10 million Georgians if you step out of line, as you heard today. And so if we don't have jurisdiction, and one of our charges is to ensure that fair and free elections. And if we don't have jurisdiction, then we damn well should, in my opinion, or somebody should, whether or not the General Assembly wishes to give us that jurisdiction or wishes to bestow that on someone else. I'll leave that up to the wisdom of the General Assembly, and having once been there. And for that reason, I want to make a motion that we have jurisdiction so that we can move forward with an investigation. And I say so without any references to the merits of it. Having read it, I have certain questions about the merits. I'm not sure how I would vote. But I do think that if we don't, somebody should have jurisdiction to investigate the Attorney General. That's why I asked about the Inspector General. No, that's why I asked, thank you, Secretary of State. That's why I asked about the Inspector General. But there ought to be accountability by every elected official, particularly on election matters. And for that reason, Mr. Chairman, I would move that we have jurisdiction, that we move forward with an investigation.
Okay, there's been a motion that the board exercise jurisdiction over the Secretary of State to hear complaints against the Secretary of State. Does that correctly state the motion? Is there a second? Second. There's been a second. Okay, so now we move to discussion. The discussion will proceed in reverse order of seniority. So Dr. Johnson, you have the floor first.
Always get to go first. Ladies first. Thank you. Well, in anticipation of this discussion, I've prepared some notes. So let me share these with all of you here and maybe those listening. It is my view that the State Election Board has the power to direct an investigation of the Secretary of State, the election officials in the Secretary of State's office, or both. A reading of the statutory provisions dealing with the board make this apparent. Although the board and the Secretary both address elections, their duties are different. The board was created by the General Assembly and given the statutory duty to ensure that election officials conduct elections in a legal, honest, and uniform manner. It is the board's duty to investigate and report election violations, fraud, or irregularities. 21-31. The board has the power to examine under oath any person concerning any matter connected with or bearing on the proper discharge of its duties. The face of these provisions provides no limit. Therefore, before the Secretary of State or his office can claim immunity from investigation, they must identify some provision of the law granting it to them. This they have failed to do. Chapter 21 of Georgia Code already provides for violations that might be part of an election complaint against the Secretary of State in OCGA 21-586 and OCGA 21-596. Many statutes in the election code refer to required conduct by an election official. The Secretary of State is the chief election official in the state. OCGA 21-250 states the Secretary of State shall receive from the superintendent the returns of primaries and elections and to canvass and compute the votes cast for candidates. OCGA 21-499 provides the Secretary of State shall immediately proceed to tabulate, compute, and canvass the votes cast. And in the event an error is found in the certified returns presented to the Secretary of State, or in the tabulation, computation, or canvassing of votes as described in this code section, the Secretary of State shall notify the county submitting the incorrect returns and direct the county to correct and recertify such returns. OCGA 21-495 states, any other provision of this code section to the contrary notwithstanding, a candidate for a federal or state office voted upon by the electors of more than one county may petition the Secretary of State for a recount or recanvass of votes as appropriate. When it appears that a discrepancy or error, although not apparent on the face of the returns, has been made, the recount may be ordered in the discretion of the Secretary of State. I believe that SEB 2023-025, which deals with the general election count and an official recount of the general election contest, is a case that pertains to the role and responsibility of the Secretary of State. The complaint is complex and large in scope. It involves alleged inaccuracies, inconsistencies, and irregularities in counts for a presidential contest in one county that represents 10% of the votes in the state. The findings in a prior complaint, SEB 2021-181, that was concluded with a consent order, found 4,081 votes that were erroneously given to one candidate and a careful review of a third of the ballots by the governor's team and Mr. Rossi and Mr. Moncla. If one were to calculate the same error rate in a 100% review of that same county, there would be over 12,000 votes given to a candidate in error. Mr. Rossi and Mr. Moncla's complaint, 2023-025, questions the accuracy of the recount and the original count of the presidential contest of 2020. They question the veracity of scanner vote totals because of lack of documentation. Mr. Rossi and Mr. Moncla allege that the recount resulted in almost 18,000 votes short and over 3,000 duplicate vote counts. According to the complaint, 10 scanners have no election documents for 20,713 votes. Perhaps the county or other election officials can produce the proper documents or evidence. There is no foregone conclusion of the outcome of the investigation, but the board and the secretary need to answer the factual questions of Mr. Rossi and Mr. Moncla. Without documentation, anyone should question the validity of results. Without proper investigation, the allegations cannot be addressed, supported, or denied. The legislature clearly provided in adoption of CGA 21233 that the board should have the resources available to conduct such an investigation with professional, independent investigators. The Secretary of State shall, the Secretary of State shall, upon the request of the State Election Board, provide any and all necessary support and assistance that the State Election Board, in its sole discretion, determines is necessary to enforce this chapter to carry out or conduct its duties. In conclusion, from the Attorney General's opinion of 2005-03, the State Election Board, this is a quote, the State Election Board fulfills its responsibilities in providing direction and oversight of the Secretary of State and other election officials when such discretion is necessary to ensure uniformity in their practices and procedures or the legality and purity of the electoral process. And most importantly, from the Office of the Governor. The Office of the Governor does not have the authority to investigate election matters. Such authority resides with the State Election Board. Thank you.
Have order, please. Can we have order, please? Thank you for your comments, Dr. Johnston. We now continue in proceeding in reverse order of seniority, and Mr. Lindsay is up again, if he wishes.
I believe I've stated the reason for my motion already. And
Okay.
no reason to prolong it.
We move therefore to Member Gazelle.
Thank you. I take this responsibility on the board extremely seriously. I spend many hours researching the law, researching the facts, reading cases, and when I was sworn in, I swore to uphold the Constitution of the United States and the Constitution of Georgia. Under the Constitution of Georgia, the Secretary of State is a constitutional office. The State Election Board is created by legislation, and we are appointed. Because of the constitutional constraints, there must be an extraordinarily explicit delegation of authority to the State Election Board to give us authority to investigate a constitutional office. And I do not read that delegation of authority in the legislation as it currently stands. The Georgia General Assembly has shown itself entirely capable of making this sort of explicit delegation of authority when, in the previous legislative session, they established a board to oversee constitutional officers in the form of district attorneys. They also wrote legislation giving us more autonomy. They did not give us an explicit delegation of authority to oversee and investigate the Secretary of State's office. In fact, in the initial draft of the legislation, they had granted us authority to hire independently our own investigators. That language was removed from the draft legislation and is no longer in there. And the implication of that change before the legislation was put before the General Assembly is that the General Assembly chose not to give us the authority to hire our own investigators. The state Supreme Court has also shown itself to view these delegations of authority extremely narrowly when they chose not to exercise the authority granted explicitly to them in reference to another oversight commission. Now, transparency and accountability are extremely important for every office, ours and every elected office, including constitutional officers. The Attorney General retains the authority to investigate violations of Georgia code, whether it's civil or criminal. We also have an Inspector General. And the ultimate authority is the voter. Now, the underlying facts of the case at hand were already adjudicated in the case of Fulton County. It was reported on in 2022. Subsequently, the Secretary of State was reelected by the voters of the state by a larger margin than any other, excuse me,
Order.
by a larger margin than any other statewide office. The voters
Order.
have demonstrated their faith, and they have held the office accountable. And therefore, I do not believe that at present we have the authority to oversee or investigate the Secretary of State.
Thank you, Member Gazelle. Appreciate that. I'd like to remind everyone here that this is a extremely serious matter. It's a very solemn event. It's the closest I've been to a constitutional crisis in my lifetime, and so it needs to be treated as such. So I caution those that don't seem to think that this is the severe matter that it is. Article 4, Section 4 of the United States Constitution provides that the United States shall guarantee to every state in the Union a republican form of government, and shall protect each of them against invasion and on application of the legislature or of the executive when the legislature cannot be convened against domestic violence. So every state is guaranteed a republican form of government and not a democracy. In my view, what we are called on today is to decide whether authority matters, and whether it matters whether we're a republic or whether we're a democracy. And if it does matter, why does it matter? In a democracy, whoever shows up gets their way by majority vote. To use the meme of the well-known movie Wag the Dog, in a democracy, if the state election board wanted to declare war against Albania, and the people who showed up to the meeting of the state election board also wanted to declare war against Albania, then the state election board could declare war against Albania. But in a republic, authority matters. Only Congress has the power to declare war. In fact, authority might be the absolute essential question involved in every single aspect of a republic. Authority between the people and the government, authority between the branches of government, authority of those answerable to the people and those with lifetime appointments, authority of those neither answerable to the people nor given lifetime appointments, but are volunteer appointees like those on the board. And so we trace the authority of the state election board and whether it has authority over constitutional officers and how they perform their jobs. In doing so, it's important to review the history of the state election board. The State Election Board was originally created in 1959 as the State Election Commission. At the time, Georgia had no uniform election code. The original members of the State Election Commission were the Governor, the Secretary of State, and the Attorney General. The Secretary of State acted as the chair, and all administrative staff for the commission was provided by the Secretary of State's office. In 1964, Georgia passed its first unified state election code. As a part of that legislation, the State Election Board was first created. The members of that original board were the Secretary of State, who served as the chair, and one member was chosen by each of the Georgia House and the Georgia Senate. The two major political parties were each given the privilege from time to time of appointing a member of its party to act as an advisor to the board. In 1968, the two major parties' appointees were made full members of the board. Thereafter, the board's composition remained completely unchanged for half a century. Passed in the aftermath of the contentious 2020 presidential election, the General Assembly in SB 202 created the new office of chair. The chair was to be appointed by a majority vote of both houses of the General Assembly, and should the General Assembly not be in session, the chair could be appointed by the governor. The Secretary of State, who had previously been the chair, remained a member of the board by virtue of the office, ex officio, but not a voting member of the board. After the creation of the office of the chair, the board operated without a chair for over a year and is currently again without anyone occupying the office of chair for over 3 months. During those times of the absence of a chair, the job of chair was performed by an acting chair, and Rebecca Sullivan was the first acting chair and did a tremendous job for the board in assuming a new role that had never existed before. I moved into the role when Rebecca left the board to fulfill other public service for the citizens of Georgia. Upon the resignation of Judge Duffy as chair on September 1st, I was again elected by my colleagues to the role of acting chair, and I appreciate their confidence in me. Prior to the 2020 election in SB 202, the Georgia Attorney General in 2005 had been asked to give an official opinion with regard to whether the State Election Board had the power to hear complaints and cases against the Secretary of State and to otherwise give official direction as to the relationship between the Secretary of State and the State Election Board. In case you want to look it up, the reference to the Attorney General's opinion is Georgia Attorney General Opinion number 2005-3. And I ask unanimous consent of the board to insert a copy of the Attorney General's opinion into the record. Dr. Johnson, okay with you? Okay, so without objection, so ordered. At the time, the Attorney General's office direction was, and I quote, "There is no indication in the law that the constitutional and statutory authority of the Secretary of State should be limited or substantively controlled by a board of political appointees who are not answerable to the electorate for their actions. Up until today, this would have been seen as a mainstream orthodox Republican view on government. After reviewing the history of the State Election Board and the powers of the Secretary of State, the Attorney General went on to write, given this legal framework, then, Georgia law provides for a symbiotic relationship between the office of the Secretary of State and the State Election Board, but it does not provide either entity with authority over the day-to-day operations of or the ability to exercise direct control over the substantive or policy-making role of the other. SB 202 made the Secretary of State a non-voting ex officio member of the State Election Board. The General Assembly at that time did not make the State Election Board independent of the Secretary of State. Even then, as it has been for almost 60 years, the State Election Board was completely and utterly reliant upon the administrative staff of the Secretary of State's office to complete its work. Even after SB 202, the State Election Board had no budget, it had no staff, and in fact didn't even have stationery. As of July 1st, 2023, as a result of SB 222, not 202, but 222, the State Election Board is beginning to start the process of becoming an independent state agency. And again, and as always, we begin and end in a republic with the question of authority. So let's look at authority of the new independent Board of Elections. In Georgia, we don't have legislative history that they do up in Washington, D.C., so the place that we look for the purpose of legislation is the preamble to the bill. The preamble of SB 222 states that its purpose is to provide that the State Election Board shall be a distinct budget unit and an independent state agency attached to the office of the Secretary of State for administrative purposes only, to provide for an executive director of said board, to provide for venue in any action of said board and its members, to provide duties for said executive director. There is no mention in the preamble of the 2005 Attorney General's opinion or the intended impact on the 2005 Attorney General's opinion in the preamble, or if it was intended to impact the 2005 Attorney General's opinion at all. There's no direction there. The portion of the actual legislation creating the Independent State Board of Elections states as follows, and I quote, "On and after July 1, 2023, the board shall be a separate and distinct budget unit as defined in Part 1 of Article 4 of Chapter 12 of Title 45 of the Budget Act, provided, however, that the board shall be attached for administrative purposes only to the office of the Secretary of State as provided for in Code Section 50-4-3. The board shall neither be under the jurisdiction of the Secretary of State, nor shall it be considered a division of the office of the Secretary of State." And that is the sum total of the legislation's statement about the board. There's nothing in the legislation about the jurisdiction of the State Election Board over the Secretary of State. The General Assembly did provide for the first time ever staff for the State Election Board, and we currently have one employee, the wonderful Alexander Harden, who does such a great job for us and for you all. I know that many people out there have come to rely on Alex to be their daily contact for information for the board, and I think y'all join us in appreciation of her great effort. The State Election Board also is budgeted for an executive director who we are in the process of attempting to hire, and we have room in the budget for one investigator. We will hire that investigator after the executive director is on board, since that person will work directly under the executive director and have a very close relationship, working relationship with them. The board currently has no active case against any constitutional officer, and nobody that I've asked in many, many months of research on this can remember that the board has ever heard a case against a constitutional officer. And so here we are again at the issue of authority. As a capital C rock ribs conservative, I'm always very dubious of the idea of an appointed board not accountable to the people, unilaterally granting itself authority that was not given to it by the people's representatives in the General Assembly and signed into law by the governor. An amicus letter sent to us from the Republican chairs of many county parties also pointed out that the authority of the General Assembly over elections is plenary. And what that means is absolute and all-encompassing. Where I am on this issue was well stated in the Attorney General's opinion, and that is, should the board believe that there are additional requirements that should be advanced in the area of election law, but which are beyond the scope of its current authority, a board is authorized to make legislative recommendations to the General Assembly. Accordingly, my inclination and the motion that I will make at the appropriate time is for the board to officially ask for a resolution from the General Assembly, or it could be in an act, which is then sent to the governor for signature, from both houses of the General Assembly to state explicitly whether it is the intention of the General Assembly that the State Election Board exercise dominion and authority over not only the Secretary of State, but all other constitutional officers. The next question that needs to be answered is, if the board were to hear cases against constitutional officers, would that authority extend only to the constitutional officer, or would it likewise extend to their staff and employees? The State Election Board frequently hears complaints that an individual poll worker was rude to a voter. The board tries to determine in these cases whether this perceived rudeness actually prevented the voter from voting or otherwise suppressed the vote. If we are to hear cases against individual poll workers, are we also to hear cases against the Secretary of State's receptionist? What about the investigators that the board relies on, who are all sworn law enforcement officers? The board gets complaints all the time that the investigators showed up with a gun and a badge, but they're sworn law enforcement officers, so that's how they present. Are we to hear complaints of this nature? And if we do, how will that impact the relationship between the investigators on whom the board is absolutely completely reliant and the board? Will we be creating the same adverse relationship that the board is working so very hard on to repair with the counties that exist currently between the board and the counties? Are we creating the problem that we're trying to fix? Next, the board serves a very important due process function to protect the rights of those who are accused of an election code violation. One of the due process rights is the right to be represented by counsel. The board's lawyer is the Attorney General. The Secretary of State, the person who would be the respondent, the Secretary of State's lawyer is the Attorney General. The Attorney General cannot simultaneously represent the State Election Board in prosecuting a case against the Secretary of State and defend the case on behalf of the Secretary of State against the State Election Board. And the way that conflict laws work, The Attorney General doesn't get to pick and choose which of the two clients to represent. The Attorney General would not be permitted to represent either party. So the taxpayers of Georgia are going to be called on to foot the bill for two sets of lawyers in every single case. Not just one case, such as Mr. Rossi's case, but upon scores upon scores upon scores of cases. A minor question that everybody seems not to think is a big deal at this time, but in my opinion, will be a gigantic deal the very first time the board votes to dismiss a case against the Secretary of State or otherwise vote to exonerate the Secretary of State, is how can the board be expected to fairly investigate its own members? Of course they'll let the Secretary of State go. The Secretary of State is a member of the board. How can the board investigate itself? We had an amicus letter state that this was not a great concern, but I'm afraid that it will be. Finally, in the event that the board does vote to grant itself the power to investigate constitutional officers and a subpoena turns out to be necessary, who would represent the board? Who would represent the constitutional officer? It's not it. Speaking very frankly and candidly, in all sincerity, when Republicans are fighting so hard in Washington, D.C. against the administrative state and an ever-expanding rule by unelected bureaucrats who are not answerable to the people, I don't see in creating that system here in Georgia. So for that reason, I would vote against Mr. Lindsay's motion, but would present a counter motion at the appropriate time after Mr. Lindsay's motion is voted on to ask the General Assembly for direction. And then I have other comments, but I think we'll move on. I do want to say, from a lot of emails that I've received and the board has received, there is an overwhelming and mistakable trend in these emails that the commenters desire that the state election board embark on an open-ended Miller-style investigation of the Secretary of State. And I just don't see any authority in the General Assembly for a broad-ranging, open-ended investigation. There's no staff for that, there's no budget for that, and there's no personnel to do that. So just to go ahead and address something that I've received maybe 100 emails asking for. So with that, unless there are other board members who would like to revisit their remarks and make additional remarks, Dr. Johnston would like to make additional remarks. So the floor is Dr. Johnston's.
Thank you, Chairman. Thank you for all of these remarks. 3 points. The current code already provides for statutes of violations against the Secretary of State. If those statutes are on the books, and then who presents the violations of those statutes? It names the Secretary of State explicitly. So are they on the books, but nobody can file a complaint against a violation of that statute? So that's one point. The other point is the Inspector General can oversee the Secretary of State, but the Inspector General is not a constitutional officer. And 3, I would entertain a motion to make this recommendation to the General Assembly for their action.
Okay. Dr. Johnston yields the floor. Mr. Lindsay, you have the floor, if you wish.
No, I think we've covered it.
Okay. Member Gazelle, any further comments? Okay, if there's no further discussion, we have a motion before the board to have jurisdiction over the Secretary of State to hear complaints against the Secretary of State. That motion has been seconded. It has been thoroughly discussed. We're ready to vote. We'll vote again in reverse seniority. So Dr. Johnston gets to go again first.
I would vote in favor.
So Dr. Johnston votes aye.
Aye.
Mr. Lindsay?
Aye.
Mr. Lindsay votes aye. Ms. Gazelle?
Nay.
Ms. Gazelle votes nay. I vote nay. So that motion fails for lack of majority. There is now a motion that Dr. Johnston, I believe, might have joined me in Or you can make the motion, or you can join my motion to use our enumerated power to request from the General Assembly that they clearly state what their intention is for the board. Does that fairly state where you and I are both kind of heading?
So moved.
Okay, there's a motion. I will second that motion. Any discussion on that motion?
No.
Okay. If there's no further discussion on that motion, we're ready to vote. We'll go in reverse. Senior.
Aye.
Dr. Johnson votes aye. Mr. Lindsay?
Aye.
Mr. Lindsay votes aye. Ms. Gazelle?
Aye.
Ms. Gazelle votes aye, and I vote aye, so that motion will be carried. Okay. We're now ready to move to the part of the board's agenda with regard to, what time do we have? It is 2:12. Oh, yeah. Ladies and gentlemen, kind of order for a second. We're in the part of the agenda that Mr. Lindsay created, and I think is a tremendously valuable tool for the board of new business. And so Dr. Johnson has some new business from the board that she would like to introduce.
New
Okay, the
business.
floor belongs to Dr. Johnson.
Thank you. I would make a motion that the board would consider a recommendation for the General Assembly to consider the end of or to consider having excuse only or removing no excuse absentee voting. And this is my proposal. Whereas absentee voting in Georgia has led to numerous complaints from the public, and the numerous reported errors are undermining public faith in the integrity of elections in Georgia. Whereas the centralization of absentee balloting and the reporting of results from the absentee ballots removes the tabulation of those votes from the local precincts. Whereas the State Election Board has received numerous complaints involving defects in the recording of absentee ballots, involving tens of thousands of votes in some elections, and often a number sufficient to call into question the results of election results. Whereas the Supreme Court has held there is no constitutional right to vote absentee, and Georgia for many years was able to conduct elections with no excuse absentee voting, without no excuse absentee voting, whereas there are many days authorized by the Election Code for early voting, and electors who are out of the country may vote under federally mandated means of voting, and whereas Georgia has had limited experience with no excuse absentee voting, and Georgia law prior to 2010 allowed a reasonable amount of absentee voting, but limited to an elector who is absent from his or her precinct during the time of the primary or election he or she decides to vote in, will perform any of the official acts or duties set forth in this chapter in connection with the primary election he or she desires to vote in, because of physical disability or because of being required to give constant care to someone who is physically disabled, will be unable to be present at the polls on the day of such primary or election. Because of the election or primary falls upon a religious holiday observed by such an elector, will be unable to be present at the polls on the day of such primary or election. Was required to remain on duty in his or her place of employment for the protection of the health, life, or safety of the public during the entire time the polls are open, when such place of employment is within the precinct in which the voter resides, or was 75 years of age or older. Whereas no excuse absentee voting was helpful during the recent pandemic, but even during that period, voting appeared to be chaotic and untrustworthy. Now, therefore, be it resolved to authorize Dr. Johnston on behalf of the State Election Board to work with the General Assembly to restore Georgia law to allow absentee voting only for the reasons embodied in this section. Thank you.
Thank you, Dr. Johnston. I'll move that be published on the board's website so that it be considered for the public and it be accepted as a matter of new business at this meeting and be open for public comment up until the next meeting, where we will treat it as old business and address it. And so that is my motion. If anyone would like to.
So we'll address the merits of it at the next meeting.
Correct. We'll publish it now for public comment and address the merits of it at the next meeting. Correct.
Thank you.
I still need a second, though.
Second.
All right, the motion and a second. Any discussion? Okay, ready to vote. All those in favor would say aye.
Aye.
All those opposed would say no. Motion carries. Okay, now we're approaching 217. We are now in the cases of pulled cases recommended for letters of instruction. We're going to take SEB 2022-217 Cobb County Records issue, item number 34 in your tabbed binders. We're going to pick up tab number 34, 2022-217. Then the next case after this one will be DeKalb County 106, so y'all can go ahead and start getting ready. Sarah Koth, Chief Investigator, the floor is yours. Be helpful if the
So I
chair
need one.
would do his job. Sorry about that. Okay, you're ready to go.
SEB 2022-217 Cobb County Records Issue. Cobb County Elections Office. The complaint was that Cobb County Elections Office unlawfully retrieved boxes of election records from the January 2021 runoff election that were under seal by the Cobb County Superior Court, a potential violation of OCGA 21-500. The second complaint was that Erica Hamilton, while serving as the elections director at the DeKalb County Board of Elections and Registration, misappropriated DeKalb County funds, a potential violation of OCGA 23-251. The complainant advised that he observed Cobb County Elections Office employee transporting approximately 6 boxes that were sealed and labeled. The investigator had requested documents pertaining to a different complaint filed by this complainant, SEB 2020-077. So what happened was the employee grabbed boxes from January of 2021 instead of the June 2020 boxes, which was requested. There were complaints for both boxes, but only the 2020 complaint had the court order. The confusion was the complainant happened to be at the elections office when the investigator had requested boxes. It was determined later that the wrong boxes were pulled, however, they were not opened. The county self-reported when speaking to the investigator, and they reiterated a reminder to double-check the process when dealing with a court order to all pertinent staff. Complaint 2 was referred to the DeKalb County District Attorney's Office regarding the allegation of misappropriated county funds. So potential violations for Cobb County: there is sufficient evidence to show that Cobb County Board of Elections and Registrations violated OCGA 21-500 when they removed records from their designated location without the approval from the court. That's it.
Questions from the board for the investigator? Question for the board from the investigator? Okay, is anybody here on behalf of the respondent? The respondent, Cobb County is here. You should be good to go.
Good afternoon, Board. My name is Tate Fall. I'm the brand-new Elections Director for Cobb County, so this is my 3rd week.
Welcome.
So you're not giving me anything easy. I appreciate that.
Welcome.
So I can't speak to when the complaint when it occurred, since I wasn't there. I'd also like to point out that our current board, none of the board members were on the board at that time, so there's not really anyone that can speak to this instance. I do have the email traffic from our former director where she did explain kind of what had happened, but I had maybe 2 questions, probably for the investigator or for y'all. First, I want to make sure, are we able to separate the complaint that's in regards to Erica Hamilton for DeKalb County? I just want to make sure, because when we got our summons, they were together, and I just want to make sure that that will remain separated, since she wasn't employed at Cobb during the time of the
I think
complaint.
Board Member Gazelle would like the floor on that. Yeah?
No, I believe that the finding in that case was that we don't have jurisdiction over that particular complainant.
Okay.
In any case. Correct?
Great.
Isn't that correct?
So we referred that to the district attorney's office.
Correct.
Okay, I just want to make sure. I know she was employed at our office, so that was in a different time.
So you won your first motion.
All right. The second question I had was, did anyone speak to the clerk of the Superior Court in the course of the investigation?
Yes.
Okay. And did they have a response as to why they maybe allowed the incorrect records to be released into our custody?
Let me double check.
Okay. Right.
I believe what the mistake was that there were two different set of boxes, and one of them was released, and they were filed around the same time, so they grabbed the wrong boxes.
Understood.
So it wasn't they released the wrong ones, the clerk grabbed the wrong ones.
So the clerk grabbed the wrong boxes.
Yes.
Okay.
So they grabbed the ones from 21 when it was June of 2020 that had the unseal.
Understood. So I know that there has been a breakdown in communication with our office and the clerk of the Superior Court in the past, so that's one of my focus areas in my next few weeks, to build that relationship. But I did want to make sure that it was pointed that they were the ones that released those boxes into our custody. And then I just had two requests, if I might. I'm sure I will be back here a lot over the next couple of months with other investigations that are ongoing. I was hoping there is a way that we could get a docket of all of the open investigations on our office and the status of those. Because even when we got the summons, I had no idea. I just went through Janine's emails and was able to find. And on kind of the same vein, if we could get the evidence that will be presented ahead of time, because I could only find what was in Janine's emails. Otherwise, I wouldn't have been able to even know kind of what the situation was before today. So just two requests from one of your newbies. I know you guys are really busy, but I would really appreciate if that's something that we could have.
I think Sarah pretty accommodating and help you as much as they can.
I'll give you till after the holidays. Just kidding.
Okay, questions by the board for Cobb County? Okay. Is
Thank you.
there any motion that a member of the board would like to make? I think Sarah, you pulled this one, right? No, Dr. Johnson pulled this one. Who pulled this one?
I moved a letter of instruction be sent.
Okay, there's been a motion for a letter of instruction. Is there a second? There's been a motion and a second that a letter of instruction be issued. Let me turn I'm going to hit the microphone. I'm sorry about that. And this is under the cases recommended for letter of instruction, so that matches the recommendation. So there's been a motion for a letter of instruction to issue and a second. Is there any discussion? Hearing no discussion, we're ready to vote. All those who would vote in favor would say aye. All those opposed would say no. Motion carries. Director Kirk, you might be here for SEB 2021-102. Maybe, I think Bartow County had a part in that, maybe? You're just here for fun. to keep informed of all the events. Okay. In case that had been continued because there was a notice issue to one of the respondents. So if you were waiting for that, I wanted to be able to release you and let you go. But we welcome you. You're always a pleasure to have with us. So grateful to have you with us. So the next case that we have up is DeKalb County, SEB 2022-106, tab number 33 in your books. They just got a message a second ago. He won't be able to be here, so we're going to have to go forward without him. Chief Inspector Koth, the floor is yours. Am I right, everybody? 2022-106, right?
Yes.
Okay. Inspector Koth, the floor is yours.
Okay.
Member Gazelle, not even Member Gazelle, Member Dr. Johnston is recognized. You have the floor.
In reviewing this case, with the kindness of the investigators, the questions that I had were very technical in nature, and they, I believe, agreed that this should be presented when Mr. Barnes is able to answer those questions. So I would make a motion that we continue this case.
Okay, there's a motion to continue. Is there a second? It's been a motion and a second. Any discussion? Hearing no discussion, we're ready to vote. All those in favor of continuing SEB 2022-106 would say aye.
Aye.
All those opposed would say no. That's going to be continued. I do note that DeKalb County was here. I appreciate y'all's patience being with us all day. You are correct, and thank you for asking to be excused, and you are excused. We thank you for y'all's attendance, and appreciate DeKalb County being here today with us. Okay, on my record, that completes cases recommended for letter of instruction, and we will move into cases recommended for referral to the Attorney General's office. SEB 2019-038, City of Arlington, number 36 in your folders.
That was continued
Oh.
for the attorney.
That was continued. Okay. Which one? Is it 28? Yeah. It's been a request for unanimous consent to take a short break, and so we will be adjourned and we'll be not adjourned, we'll be in recess for 15 minutes. Hearing no objections. Okay, we're going to reconvene, come out of recess, and we're ready to pick up where we left off. Cases recommended for referral to the Attorney General's office. Tab number 37, SEB 2021-07, Chatham County. Inspectors from the Secretary of State's office, the floor is yours.
So this particular complaint.
Well, helps if the chair does his job.
Okay. So this case involves a couple of allegations that involve a number of individuals. The first allegation, Renee Schmid, alleged a U.S. postal worker stole 2 absentee ballots out of the mailbox on October 3rd, 2020, was the first allegation. The second allegation is Inger Bostic reported that Chatham County voters Mark Hiatt, Julia Garcia, and Hattie Mobley voted twice during the November 3rd, 2020 general election. So we'll start with the first allegation. Peter and Renee Schmidt's absentee ballots were delivered on October 1st, 2020. However, they were out of town and the ballots remained in the mailbox. The ballots were removed by a different mail carrier on October 3rd, 2020. They knew the ballots had been delivered because they had subscribed to informed delivery. The same ballots were later redelivered on October 7th, 2020, and were sealed and had not been tampered with. The Schmidts had surveillance footage which showed a female mail courier remove the absentee ballots on October 3rd, 2020. In the footage, it appeared the mail carrier simply removed the ballots out of the mailbox as if it was believed to be outgoing mail. Mr. and Mrs. Schmidt do not have a traditional mailbox and instead have a basket with no flag to indicate outgoing mail. Ultimately, Mr. and Mrs. Schmidt were able to vote their absentee ballots without any further incidents. For this particular allegation, there is no evidence to support a violation of Georgia election code. I can continue. Any questions on the first allegation?
Any questions from the board on the first allegation? Yes. Okay, Sarah Gazelle. Member Gazelle? Get you next.
Was there any indication in the investigation file why voter credit was not in, at the time it was ENET, for Mr. Hiatt when he went on election day? If he had already submitted a ballot, that credit should have shown up
I was dealing with
in the file.
The first allegation
Oh,
was the mail.
sorry.
Yeah, I was going
I was
kind
looking
of
at allegation number 2.
allegation by allegation.
Sorry. All right.
Protocol foul.
Yes. Apologies, I got ahead of you. I have no questions on number 1.
Okay.
Okay.
Allegations. Did Mr. Schmidt notify the post office that immediately that they saw their ballot had been removed by the postal worker from their mailbox?
You know, we didn't ask him that question. We did follow up with him later, asking him, was that the only mail? We found out it was the only mail in his box at that time. He believed that it was the fact that the mail was left in the box for 2 days and that the mail carrier simply, oh, here's, boom, and then took it back out. That's what he believes.
Yeah.
But I think it was his wife that filed the complaint.
Okay, so there was no other mail, just absentee ballots
Yes.
in the mailbox, and those were the only things removed by the postal?
By the mail carrier.
By the mail carrier?
Yes.
Okay. And were you able to find out if the election office uses scanning capabilities of all their election mail, outgoing, incoming?
No, we weren't able to get the answer to that.
I would love to know that, and actually, that would be, I'll consider a motion to propose that all election mail be scanned and images made available to the public, but that's another another issue.
Okay,
That's the only question I have.
okay. So for allegation 2, it was,
Okay. We're ready for allegation 2. Okay.
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 Please proceed.
All right, so for allegation 2, it was confirmed that voters Mark Hewitt and Julie Garcia voted twice during the November 3rd, 2020 general election. Mr. Hewitt admitted to voting both during the advance voting period and on election day. Mr. Hewitt said he only voted a second time after his wife, Connie, discovered that his first vote had not been registered. He went to the polling precinct and the worker checked the system and it showed he had not voted. The worker told him he needed to vote, so he did as instructed. He indicated that his intention was not to commit voter fraud and only voted a second time because he thought his first vote was not accepted. During a follow-up interview, he clarified that after she checked the computer, that's his wife, she spoke with her poll manager, who advised her to contact Chatham County Election Office for further assistance. Mrs. Hewitt did so and claimed the individual she spoke with advised that her husband should go to the polling location on Wheaton Street, where they could check to see if her husband had received credit for voting. Mrs. Hewitt said her husband went to the Wheaton Street polling location where he voted after being told to do so by a poll worker. Mrs. Hewitt did not recall the name of the individual she spoke with from the Chatham County Election Office. Mr. Hewitt explained he presented his driver's license, asked the poll worker to check and verify if he had voted or not. He claimed that the poll worker told him he had not yet voted, so he in turn asked what he was supposed to do. Mr. Hewitt said at the direction of the poll worker, he voted. The Wheaton Street polling location was identified as the River Point Community Center. Investigator Blanchard followed up with the Chatham County Election Supervisor, Billy Wooten, to identify the poll worker Mr. Hewitt spoke with on Election Day. Unfortunately, the 24-month retention period had passed and the poll worker information was no longer available. Now, in doing some further review of the process, it appears that when he voted absentee in person, someone should have entered that information into eNet, and that would have prevented him from being able to vote that second time. So we did look into that, and that would potentially be a violation on Chatham County's part of SCB Rule 183-1-12.11 sub 2 sub A, which states the poll officer shall verify the identity of the person and that person is a registered voter of the precinct, and if so, shall approve the voter certificate and enter an appropriate designation on the electors list for the precinct reflecting that the voter has voted in the primary election or runoff being conducted. The voter's name shall then be entered on the appropriate list of voters. You want me to pause after each person or just continue to go through the other two individuals that were accused of double voting?
If you don't mind, I'd like to address this because I'm not sure I will remember all the details. And at the appropriate time, I would like to make a motion that we initiate a complaint against Chatham County on this basis because they have not received notice because they're not a respondent in this case. I would like a case opened in reference to this because it's very, very serious. If a county fails to appropriately document when voters have cast a ballot, and it gives them the opportunity to cast two votes in the same election. So
I'll treat that as a unanimous consent request. Is there an objection?
No.
Without objection, so ordered.
thank you.
Okay.
Thank you.
All right, so we'll go into the second.
I have a
I'm sorry.
question. So I would also point out that when one is voting absentee by mail, one has to rely on the postal service also. So when you decide to vote by mail, you're subject to how many days it takes that ballot to be returned to the election office. And if scanning were instituted of all incoming mail, you would have a document of the evidence of the day that ballot was returned to the office, besides relying on the election office to document that also. And also, one has to rely on My Voter Page being accurate for people to refer to, because voters refer to My Voter Page to see if their ballot indeed was received and accepted. And if it's not, they become anxious every day thereafter. And some are led to voting a second time, innocently thinking it was lost in the mail or stolen or whatever, and they commit a felony. They double vote. So it's a multiple step potential problem.
Can I clarify? I had understood that this was an absentee in person. This was an advanced in-person vote.
Yes, it was.
Oh, sorry, I thought
The
it was a
first
double
and,
vote.
the second two, though, are,
Right.
yes. But the first one was absentee
Why
in
those
person.
comments to the second two then?
So,
Further questions for the investigator from the board? If not, I'm ready to hear a motion on one or both or all. Mr. Hyatt, press the button on the little metal thing in front of you. It says talk or speak or, there you go, I see you. Okay.
Yeah. The description was pretty accurate. Actually, I voted, like you said, my wife is a poll worker, so I voted in advance, and then after the election the next Tuesday, I was at home. My wife, a poll worker, called and said, you know, my vote had not counted. So I said, what do I do? And she got with the poll worker supervisor and said, I need to go down to Wheaton Street where I normally vote. So I did, and I voted. She looked at my ID. I said, what do I do? She said, well, you need to vote. So I voted. So I went to the scanner, and I just wanted to make sure how you put the vote in, you know, upside down or whatever. Said, doesn't matter, as long as it makes the beep and you see the little number change, your vote is registered. So I did that. So I go home. About 3 hours later, Connie calls me from the poll and says, when are you going to vote? I said, I voted 3 hours ago. She said, it's not in the system. I said, well, how can that be? So I voted twice and no recorded vote. So I called the Secretary of State's office, left a message. I called Buddy Carter's office. I didn't leave a message there. And I told Connie, I said, what are we going to do? She said, I'm going to call the head office, poll office, and let them decide. So she did. They said they were going to investigate. So about 5 o'clock, I called and I said, I haven't heard anything. I want to come talk to them. I'll be glad to call them or whatever. She said, no, they're going to investigate. So the election happened at 7. And far as I knew, I didn't have a vote. So the next day at 10 o'clock, she gets a text, and it's from the board office saying that they were going to accept the Wheaton Street vote, which I didn't understand how you can add a vote after the election, or maybe it was before, I never heard. So as far as I'm concerned, I didn't really get a vote. I don't know. So it's either the machine or something. I don't know.
Mr. Chairman.
Member Gazelle?
It was definitely, each one, when I scanned it, it made a little noise, and you could see the number flip over, and I never got a vote.
Thank you, Mr. Hyatt. Member Gazelle?
Mr. Hyatt, I'm very sorry that some of the people assisting you did not give you appropriate information. When you scan your ballot in the scanner, then your vote is added to the totals. So in fact, from your description, you had not just one vote, but 2 votes that you cast were counted and included in the vote totals. Getting credit in the system for having cast your ballot is something that sometimes takes time. It should not take time, but the system takes time to catch up, particularly on Election Day, because in the past, Election Day votes were static in the poll pads. In other words, that information would not get uploaded into the central system until afterwards. It has been updated now. We're looking at a new system where votes should be recorded almost simultaneously. They should have during your early vote as well, and that is why we're going to initiate an investigation into the county to see why it did not get properly recorded. But if any voter is casting a vote in person, they scan it in there, the scanner records it, that vote has been cast and has been counted. It may take time for that to show up on MVP, on the rolls, because some counties use a different interface that takes time to load that information up. And unfortunately, you were not given the appropriate instructions in this case, and that's where.
The only question I have, we voted at the same time in
Mr. Hyatt, I'm asking you a favor, if you hold the microphone a little bit closer, there's
we
people
both-
watching on the internet that want
We
to
both-
hear you.
We both voted at the same time in advance voting. I don't know why mine would not show up after 5 days.
And that's why I requested that we initiate an investigation in that as well. But I just wanted to assure you that your vote counted not just once, but twice.
Okay, what's the pleasure of the board? We've already approved by unanimous consent opening an investigation into Chatham, but what's the pleasure of the board with regard to allegation 1?
When you put your ballot into the ballot box, you have to trust that it's counted. Getting credit for it in the electronic system or on your My Voter page is really a different step. And there was a flaw in the system that required one additional step to send that credit for voting to the main server that connects or syncs with My Voter page. So when you cast a ballot and you feed it into the ballot box, you have to trust that you have voted, and you cannot vote a second time if you don't see credit for it. If it's not on the web page or in My Voter page or even in somebody checking on your behalf to see if the credit was given. So be careful, do not vote twice.
Okay. So, what's the pleasure of the board with regard to allegation 1, that there was a recommendation of no violation? Do we accept that or reject that, or what's the?
Move to accept.
Move to accept the recommendation of no violation with regard to allegation 1. Is there a second?
Second.
Any discussion? Hearing no discussion, all those in favor would say aye. All those in favor would say aye.
Aye.
All those opposed would say nay. Okay, so there's no violation is adopted on allegation 1. Is Julia Garcia or Hattie Mobley here? Julia Garcia, Hattie? Nope. Yes. Yes, I recall. Thank you for refreshing my recollection on that. Okay, what's the pleasure of the board with regard to allegation 2? There's three respondents. What's the pleasure of the board?
I move that they be.
Take these separately.
As a unanimous consent request to take them separately. Any objection? Without objection, so ordered. So we'll do Mr. Hyatt first.
I would move to dismiss with a letter of instruction.
So a motion to dismiss with a letter of instruction. Is there a second? Is there a second? That motion fails for lack of a second. What's the pleasure of the board?
I move that this case be referred to the Attorney General.
Okay, there's been a motion to refer Mr. Hyatt's case to the Attorney General for processing. Is there a second?
Second.
There's been a motion and a second. Any discussion? Hearing no discussion, all those in favor would say aye.
Aye.
All those opposed would say no.
No.
The motion carries 2-1. With regard to Respondent Julia Garcia, what's the pleasure of the board?
I move that it be referred to the Attorney General.
A motion to refer to the Attorney General. Is there a second?
Second.
There's been a motion and a second. Any discussion? Hearing none, all those in favor would say aye.
Aye.
All those opposed would say no. Motion to refer to the Attorney General passes unanimously. With regard to Respondent Hattie Mobley, what's the pleasure of the board?
I move that it be referred to the Attorney General.
There's a motion to refer to the Attorney General. Is there a second?
Second.
Motion and a second. Is there any discussion? Hearing none, we're ready to vote. All those in favor of referring Respondent Hattie Mobley to the Attorney General would say aye.
Aye.
All those opposed would say no. Motion carries unanimously. We'll now move to case number SEB 2020-2017, Clinch County, tab number 38. Tab 38. Secretary of State's office, the floor is yours.
On November 23, 2020, investigations received a complaint regarding Clinch County Registrar's Office failed to mail out 2 Uwakava ballots by the deadline regarding the January 5, 2021 runoff. The investigator contacted Ms. Balance, the Clinch County Registrar, and she admitted she missed mailing the ballot for voters Chandel Clark and Ms. Ford by the November 21st, 2020 deadline. Ms. Balance submitted sworn statements addressing each voter. She advised she would send the investigator the emails where she attempted to contact the 2 voters, but the investigator didn't receive the copy of the emails. The potential violations, OCGA 212384, subsection A2, on mailing of ballots for Ms. Balance.
Okay, any questions for the investigator by the board? Is anybody from Clinch County here? Clinch County? Clinch County? Clinch County? Okay, hearing none. What's the pleasure of the board?
I move that we refer this to the Attorney General's office and use the opportunity to remind counties that when they are called as respondents, it is in their best interest to come and explain the situation.
Okay, there's been a motion to refer to the Attorney General with an admonition to those listening. Is there a second?
Second.
Multiple seconds. I'll take that as no discussion. So we're ready to vote. All those in favor would say aye.
Aye.
All those opposed would say no. Motion carries to refer to the Attorney General, carries unanimously. Next case is 2020-247, Lowndes County. Lowndes County. Tab number 39. Secretary of State's investigator, the floor is yours.
Yes. Lowndes County Election Supervisor Deb Cox submitted numerous voter registration applications that were deemed potentially problematic due to handwriting and signature issues. All the voter registration applications came from an organization named Hard Knocks LLC. Special Agent Zachary Johnson of the GBI Georgia Bureau of Investigation interviewed all witnesses and respondents that he was able to locate. Through the information obtained in the interviews and supporting documentation, he was able to identify 3 respondents who admitted to fraudulently completing voter registration applications. The respondents were identified as Renee Brown, Jania Seawright, and Jewel Wims. It should be noted that all Hard Knock LLC canvassers were required to initial their completed voter registration applications in order to gain credit. The majority of canvassers interviewed said Hard Knocks LLC set voter registration application quotas, and if not met, they were threatened with termination. Renee Brown worked as a canvasser for Hard Knocks LLC and was linked by her initial to voter registration applications for Malacia Petway and Jennifer Lux. Both Petway and Lux reviewed their respective voter registration applications and both said they were fraudulent. Jania Seawright identified herself as a friend of Hard Knocks LLC canvasser Lakima Joyce. In an effort to help Mrs. Joyce with her quota, Ms. Seawright admitted to fraudulently completing voter registration applications for various family members, including her mother, grandmother, uncle, aunt, and a friend. All 5 registrants reviewed their respective voter registration applications and all said they were fraudulent. Mrs. Seawright admitted to completing the applications without consent or speaking to any of the individuals listed above. Each of the applications Mrs. Seawright completed had the initials LJ on the back, except for Jessica Wright's. Jewel Wims admitted to completing 6 voter registration applications for the following individuals: her father, her aunt, actually 3 of her aunts, a friend, and 2 of her friends. Mrs. Wims claims she contacted each individual over the phone and received consent to use their information and sign their names. By her own admission, each of the 6 voter registration applications were completed outside the presence of the applicant. And at the time of the investigation, initially, we could not find those applications. However, we did find one of them. Actually, today, we were able to find one of the applications that we couldn't find before. So just as a note, GBI analysts ran investigation intelligence queries, which showed that 5 out of the 21 names listed on voter registration applications were residents of Florida. And there are some names here. So basically, based on this investigation, some of the recommended or potential violations that we identified were against. Now, there's Tisa Moore listed. She's a supervisor. We didn't have anything to specifically tie her to the fraud, but we had other cases that were similar in nature, and I know that the board would like to talk to some of the representatives, and so that's one of the reasons why we listed her as a respondent for this particular complaint. But obviously, we listed Jania Seawright, Renee Brown, and Jewel Wims as respondents in this case based on their actions. And
Okay,
that's
thank
it.
you. Questions for the investigator by the board? Dr. Johnston has the floor.
Is there any information from your investigation or the GBI's investigative report that suggests that Hard Knocks acts as an agency that directs the fraudulent voter registrations?
No, that tells their canvassers to,
Right. My question is, are they encouraging or influencing or requiring these workers to obtain voter registrations, whether they're legal or not?
I don't think we have any overt information that that's the case. I think it's, you know, you have to have your 10 folks or you're going to be fired. So I think from that pressure, obviously, individuals are unfortunately engaging in this type of conduct. So I don't think we found any evidence that, overtly said bring us, false or fraudulent, but it's just the pressure and people who work there want to get paid. So I think that's kind of the impetus for this.
Were the training documents that Hard Knocks uses to train these voter registration folks, were those reviewed, or did they have training documents, or did they say what sort of training they underwent to register voters?
Let me look at the case file.
Okay.
Quick, just to.
So the question I'm wondering for this and possibly another case is whether to make a motion to add a complaint violation of conspiracy to commit election fraud, 21-2-603. If an entity is requiring people to commit acts such as false voter registrations, then maybe there should be some accountability to an agency such as that.
Subject to hearing from the respondents, I might be add to that.
I mean, if this was important enough for a GBI investigation, that may suggest that they were concerned also. And we've certainly seen enough of similar cases that I think these need to be looked at seriously.
Is anyone from Hard Knock Strategies LLC here? Tessa Moore, Janiyah Seawright, Renee Brown, Jewel Wims, Hard Knock Strategy. Tessa Moore, Janiyah Seawright, Renee Brown, Jewel Wims. Hearing none, hearing no response. What's the pleasure of the board? Member Gazelle?
I'm deeply disappointed that no one from Hard Knocks is here. This is the sort of behavior that gives good, hardworking organizations that conduct excellent, clean voter registration drives a terrible name. Quotas should never be used because it creates a perverse incentive. And I don't see any evidence of an intent to commit voter fraud here. There's nothing in the record that would suggest that was the goal here, and I think that's assuming facts that are not in evidence, but clearly quota systems are terrible. Quota systems make people who just want a paycheck make things up. And that's what leads to this kind of behavior, and that should not be allowed. I have not done the homework to see whether or not that is illegal within the context of third-party voter registration drives. I will do that, and if it is not explicitly prohibited in Georgia code, I will, in the future, make a recommendation that we prohibit that sort of organizational behavior, because it creates perverse incentives and it creates an enormous amount of work for the counties to sort through this and have to come all the way up from Lowndes County to have to deal with this sort of thing. And I am enormously frustrated when I see this. So I just wanted to put that on the record.
Okay, so the way,
If I may, while
Member Lindsay?
there may not be direct evidence of fraud, there's certainly circumstantial evidence of fraud. And for that reason, at the appropriate time, not only will I make a motion to send to the Attorney General, but I'd also make a motion to send back to, is it Lowndes County District Attorney for further investigation as to criminal conduct.
You ready to make that motion now?
Yep.
Okay, so Member Lindsay has made a motion to send the case to, with all defendants to the Attorney General and a recommendation to the District Attorney. Dr. Johnston has also spoken about adding a count for conspiracy to commit election fraud. The defendants didn't have notice of that, so that would that would have to be noticed to them, and we would have to hear that at a future hearing. But there's nothing that says we can't do that. So right now, so let's make two different motions. One to send to the Attorney General and the District Attorney. Is that fairly stated, somebody's motion?
Yes.
Yes.
Mr. Lindsay's motion, is there a second?
Second.
Dr. Johnston seconds. Any discussion? All those in favor would say aye.
Aye.
All those opposed would say no. There's no objection, so it passes unanimously. Now there's a second motion pending from Dr. Johnson to add a count of conspiracy to commit election fraud. Is there a second? That would need to be renoticed by the by the Secretary of State's inspectors. Is there a second?
Yeah, I'll second that, because I'd like to have a further investigation on that. I hear the concern as to whether or not there's any direct evidence, but I would like some additional investigation as to that.
And Dr. Johnston, please give me that code site again, please.
That is 21-2-603.
603, 21-2-603. So there's a motion to add a count that will be noticed to the respondents of conspiracy to commit election fraud under 21-2-603. Is there a second?
Second.
Okay, any discussion? Hearing no discussion, we're ready to vote. All those in favor would say aye.
Aye.
All those opposed would say no.
No.
So there's 2-1. Okay, we're ready to move on to the next one. Tab number 40, Monroe County Nomination Petition.
We've already done that one.
Oh, great. Refresh my recollection how that was resolved. You remember?
Yeah, we dismissed some, we sent some to the Attorney General,
Yeah.
and we sent some letters of instruction, and one letter of
Ah, yes, that's Sam Olin's case. Yes. Okay, thank you. I needed a hook. I needed a hook to access that. You're absolutely right. Thank you so much. That's right. We sure did. Thank you so much. It's terrible getting old, isn't it? SEB 2020-265, Worth County. The floor, it belongs to the inspectors.
Okay. The Worth County Board of Elections was concerned that a person had intentionally tried to register to vote multiple times and had requested multiple absentee ballots. The Worth County Board of Elections reported that Mr. Daniel Merle Crawford has 3 registration accounts and numerous absentee ballot applications. It was also reported that Mr. Crawford spells his first name with a Y and an IE at the end, that he sometimes goes by the name Donnie instead of Danny, and that there are discrepancies in the addresses used. Mr. Crawford was interviewed by one of our investigators, and he indicated that the ballot/applications kept coming in the mail, so he would complete them and send them back. The investigator asked Mr. Crawford how many absentee ballots he sent in, and Mr. Crawford stated he doesn't know how many he mailed in. The investigator confirmed that Mr. Crawford was involved with establishing 3 voter registration accounts. Each of the 3 spellings of his first name all maintain the same or similar pronunciation. Other than the 3 spellings of his first name, all maintain the same or similar, you know what, I just repeated it. Other than the spelling of all the pertinent information, identifying information, middle and last name, birth date, and address is the same on each account. Worth County Election Supervisor, Mrs. Brandy Harris, documented in her handwritten timeline, quote, "We should have caught the duplicates." Mrs. Harris and the Worth County Board of Elections and Registration believe they have identified the problem that allowed the multiple voter registration accounts to be established and contend they have implemented measures to prevent it from occurring again. A separate complaint identified and made by Mrs. Harris during this investigation is the fact that Mr. Crawford was able to cast 2 absentee ballots that were accepted. The ballots were cast via voter registration account two separate ones, one with a registration date of 7/27/2020 and the other one 7/7/1980. These two accepted absentee ballots were for the November 3rd, 2020 general election. During a recorded telephone interview with Mr. Crawford, he reiterated that the ballots just kept coming, so he filled them out and sent them back. Ultimately, the only way that Mr. Crawford was able to have two absentee ballots accepted for the same election is because the Worth County Board of Elections and Registration allowed multiple accounts to be established in Mr. Crawford's name. So the potential violations for Mr. Crawford: OCG 21-2572, repeat voting in the same primary or election, and also OCG 21-226A, duties of the board in determining eligibility of voters, maps of municipal boundaries, etc. And then also Brandy Harris, Worth County Election Supervisor, Worth County Board of Election and Registration. There is evidence to suggest that Brandy Harris and the Worth County Board of Elections and Registration were in violation of OCGA 21-226A when he was able to establish three separate voter registrations account, all under the same last name and other personal identifying information, one count.
Okay, questions for the investigator by the board?
Mr. Chairman,
Member Gazelle?
can you tell me how old this voter is?
He is 63.
Are you here?
For the record, Dr. Johnson just remarked on how young he was.
Supervisor.
Comment. Is anybody here from Worth County? Worth County. Welcome. We're glad to have you here today. If you'll press on the button in front of you, I'll turn on a microphone for you. Okay, great. Please identify yourself for the record. You're free to stand if you wish or sit, either one, whichever is your pleasure.
Okay, thank you. My name is Brandy Bowles now. I got married in 2021.
Well, congratulations and best wishes. That's wonderful.
Thank you. Thank you for having me. This is my first time at the Capitol, unfortunately, under these circumstances. But I do have a statement I put together, if I can just read that to you.
The floor is yours.
Thank you. I'm the supervisor, again, for the Worth County Board of Elections. This investigation actually began when I self-reported my concern of a person, Mr. Danny Merle Crawford. He sent in multiple registration forms and received multiple absentee ballots for the November 2020 and the January 2021 election. As to the voter registration submissions, Mr. Crawford submitted voter registrations on July 6, 2004 in the name of Donnie with an IE, and on August 2016 in the name of Danny with a Y. In 2020, registrations were sent in the name of Danny with an IE on July 27th, September 14th, September 20th, and September 23rd. Although much of the information, such as the address and date of birth, remained the same on the registrations, the Worth County Board of Elections and Registration provided 3 accounts. The first account was for Donnie, one for Danny with a Y, and one for Danny with an IE. The first account appears to have been created in 2004 under Donnie. In 2016, when he filed a registration again, the registration at that time caught it and merged it. In 2020, Mr. Crawford filed 4 different registrations within 2 months, providing the name with a Y and IE. There were 2 different accounts created for each. On the account created for Danny with an IE, there is a different Social Security number in the system. As to the absentee ballots, in the 2020 election, he requested 5 absentee ballots in the 2 elections of November 3rd, 2020 and the January 5th, 2021. Through rollover and other applications. For the November 3rd, 2020 election, under the account of Danny with a Y, a ballot was requested and issued. That vote was counted in the election. Under the account for Danny with the IE, a ballot was requested and issued. That vote was counted also in the election. I discovered the issue with Mr. Crawford on December 9th, 2020, and reported the issue to Blake Evans, the elections director. For the January 5th, 2021 election, there were 3 ballots requested and issued, which were issued prior to December 9th. However, only 1 ballot was accepted under that account. And also, I want to state at that point, I put him in a challenge status. So if, you know, he were to come in and try to vote any other way, he would be flagged. So the end result is that Mr. Crawford voted twice in the November 3rd, 2020 election. As I've explained, this occurred due to the two registration accounts that were created due in part to the name variation. As I know the board is aware, I'm sure we're all tired of saying the word or the numbers 2020. It was the first general election conducted with the pandemic with the new equipment. We have 1 full-time and 1 part-time employee and a working board that usually comes in during elections. We're one of the smaller counties. The number of poll workers at that time went from 78 to 20. Board members, staff, myself, or our family members living in our homes with us were all in the higher risk category. The protocols for handling absentee ballots, including sanitizing ballots, use of gloves, masks, increased the time it took to handle those ballots. And as the board is aware, the number of absentee ballot was unprecedented throughout the state of Georgia during this election. In Worth County, we had a 533% increase in the number of absentee ballots. So the number of ballots dramatically increased, the time to process the ballot increased, and we had far few people performing work under very difficult circumstances. I offer all this information not to excuse anything, just try to explain, at least in part, why it happened. Hopefully we will never have to experience again, but with every type of experience we do learn from it, and we have learned from it. So I do offer solutions. We have implemented many things since then, and I thank you for
That's
letting me.
music to Board Member Lindsay's ears.
Great.
He loves solutions.
Yeah.
Well, good.
Because we have a lot of folks around the state who do listen in from boards. So what were some of your steps that you took or you think
Okay.
needs to be taken to make sure this sort of thing doesn't happen again?
Well, in our defense, there was not a lot of people, there was only 1 to 2 people doing absentees, and then everybody that came in to help us with the influx was, you know, trained on the fly.
Sure.
We're opening, sanitizing them. It was just insane. So I do have an absentee ballot clerk that she's the only one allowed to do it, but we
Okay.
do help stamp and process. But it's nothing like the amount of ballots we had then. We do now use Google Forms and Google Sheets that as a numbered list for the absentee ballots and the applications. And also we're using it with the voters list. We're sending the voter list to a Excel spreadsheet and filtering it by date of birth and filtering it by the first name so that we can find any duplicates that way. This makes it easier to find the duplicates and document any complications. With the implementation of SB 202, only authorized people can send applications. This has helped in lowering voter confusion and clerical errors on our part, so we are happy about SB 202 with that part, because the voters were calling all the time. They were confused. They were getting applications from everywhere, including us, so everyone was confused. Our office is more vigilant in preventing duplicate registrations. We check more than just the name. We check the date of birth, the address, and all the other pertinent information. It's important to be detail-oriented. I believe the state has changed to the Jarvis system, and I believe that will help us catch some of them, but we don't depend solely on the registration system. Lastly, we have added the other ballot clerk. So that was my last one. And I just thank you again for letting me speak.
Thank you for your comments. Just kind of one statement for the board with regard to institutional memory is that the board has traditionally treated self-reporting cases in 2 different manners. And one was, I did something wrong and I'm self-reporting that I did this. And in the other instance, somebody tricked me into doing something and I'm self-reporting it. And we've always wanted to not discourage people from self-reporting either example of those instances. So just kind of bring us around of how we've traditionally handled cases like this. But now turn it over to the board to find out what the board's thinking is, unless Mr. Crawford is here. Mr. Crawford is here. No?
I believe he actually showed up at our office in Worth County in Sylvester. He may have been a little confused
Okay,
of
so
where to go.
Okay. So he was down in Sylvester. Okay. Well,
But it was only 63, so that's not an excuse.
all of us up here that are 63 think that's a perfect age.
All right, in all seriousness, I'd like to bifurcate and treat these two separately.
Okay. There's been a unanimous consent request to bifurcate and treat these as separate. Is there any objection? That objection so ordered. Mr. Lindsay has the floor.
As to the county, I would move to dismiss with a letter of instruction.
There's been a motion to dismiss with a letter of instruction as to the county. Is there a second?
Second.
It's been moved and seconded. Is there a discussion? Dr. Johnston
yeah.
has a discussion.
So, I'm kind of conflicted. It's a wonder that Mr. Crawford didn't vote about 10 times from all the voter registrations. 5 applications, 3 voter registrations, 2 votes, and 1 person. That's, maybe it's multiple personalities or something.
One other thing I can say to that is that was at the time period where Runbeck, we could opt in for Runbeck to send all of our rollover ballots, and since he was on the rollover on 2 of those accounts, it automatically sent him ballots, and then it went from there.
Bonus. I did check Worth County for your citizen voting age population percentages, and I commend you because you seem to have good voter rolls. I agree that he should have not slept through, and your corrective measures I adore. I love hearing that. So I hope all the counties are listening and will follow suit. Thank you.
Motions from the board. We've got a motion to dismiss with letter of instruction that has been seconded. There was discussion. Now we're ready to vote. All those in favor would say aye.
Aye.
All those opposed would say no. Motion carries, and now we are, what's the board's pleasure with regard to Mr. Crawford?
Mr. Chairman, I would move to refer the matter to the Attorney General.
Motion to move or to refer to the Attorney General for processing. Is there a second?
Second.
It's been moved and seconded. Any discussion? With regard to discussion, I'm disturbed on this instance with the changing of the spelling of the name shows some sort of culpable intent in my mind. So I agree with the referral to the Attorney General. Any further discussion? If there's none, we're ready to vote. All those in favor of referring to the Attorney General would say aye.
Aye.
All those opposed would say no. Motion carries unanimously. If you'll excuse me for just 1 second, I need to respond to an urgent email that requires immediate attention. So if you excuse me for just a second. Okay. It was always more sinister in your minds than what it actually was as a doctor's office wanting to know if I can make an appointment. So I needed to let them know that I was available so that I didn't lose the appointment. So thank y'all for y'all's indulgence. Okay, we're ready to move to the next matter. I've got 42 Chatham County Poll Watcher issue 2020-279.
Okay.
Everybody agrees we're on tab 42. Investigators, the floor is yours.
Okay, this complaint was brought by Russell Bridges, who is the retired election supervisor for Chatham County. And he indicated concern that a Christina Maliman came in as a poll watcher and covertly filmed around the operations, which is directly in violation of OCGA 21-2-408 sub D regarding poll watchers, designation, and duties. He also provided a link to a video that was posted online by Mrs. Maliman with NTD News, New Tang Dynasty Television. And there's a title, there's a link where the video is. I actually watched the video. And this was during the presidential race recount. He also talks about some of the statements, the incorrect statements that she makes on her video. He lists the following: that she misidentifies network switch boxes as internet modems. She also misidentifies a uninterruptible power supply, also known as a UPS, as a server. She also misidentifies a security key reader as a USB flash drive, and that she also alleges that these items were connected to the internet. Mr. Bridges states that she illegally filmed almost all the footage that takes place at the annex within the private area while she was there in her capacity as a poll watcher. And
she was also on the vote review panel also. She took an oath to be on the vote review panel when she did these acts.
Okay, step toward the microphone so that the court reporter can take this down, please.
Yes, sir.
Please identify yourself.
I'm Glenn Archie. I work with the Secretary of State's Office of Investigations in Macon.
Welcome, Investigator Archie.
Yes, sir.
If you please repeat that for the court reporter so she can take it down.
Yeah, I just want to add that she was also a member of the vote review panel, and she took an oath to be a member of that. That's how she gained access in those areas.
Okay, thank you. Inspector Archie. Questions from the board? Questions from the board?
Question.
Dr. Johnston?
Chairman Mashra, for Mr. Archie. It says she was behind the enclosed space. Does that mean she was within the enclosed space? What does behind mean?
Well, the way they set up their annex,
If you'd move closer to the mic, I'm sorry to fuss at you. I don't mean to fuss at you.
they set up their annex. They put like a 2x4 framed wall around the area. They put plywood on the bottom. The top area had plexiglass where people who just want to come in to watch, they would stay outside that location. All the workers would go inside that area where they had all the equipment when they did the recount. She was in that area as one of the members of the review panel.
Looking through the plexiglass?
No, she was inside the area
Inside.
working as a member of the review panel.
Oh, she was working when she took the video?
Right, she was on the review panel.
And the election was over. It was
Right.
during the recount.
Yes, ma'am.
Well, my opinion is, once the election's over and the votes are cast, that I think photographing and recording is perfectly acceptable. I know that's not the rules that are written, or they may vary depending on the action that's taking place or what part of the election process is undertaken.
Mr. Lindsay?
Well, while I respect Dr. Johnson's opinion, the fact of the matter is we can't have folks on their own violating the law. The remedy is very simple. You go to the General Assembly to change the law, or you come to us if it's a rule. But you don't simply just take it upon yourself to ignore a written prescription, prohibition.
Member Gazette?
I think it's also important to note that not only was it filmed, but it was also posted with incorrect information, disinformation with regard to the processes that were being witnessed and recorded, and that disinformation is what has helped fuel a lot of the conspiracy theories about internet connections with our system, and that is incredibly damaging.
Okay, Christina Malaman. Christina Malaman. Is Christina Malaman here? Christina Malaman. Okay, any further questions by board members for the inspectors? Any board member would like to make a motion?
Move to refer to the Attorney General.
It's been a motion to refer to the Attorney General. Is there a second?
Second.
It's been a motion to refer to the Attorney General, and that has been seconded. Any further discussion? Ready to vote? All those in favor would say aye.
Aye.
All those opposed would say no.
No.
Okay, the motion carries 2-1. Okay, Richmond County was continued. That was number 43. Richmond County was continued, so we're now into Chatham County residency issues, number 44. 44 in your tab. Case number 2020293. Investigator Archie also on this one, so we might have you back at the mic in a minute, but for the investigators, the floor is yours.
Mr. Chairman, before
excuse
we
me.
do that, Alex, in one of our, visits to various boards, in one of our visits to various boards, I think it was me and Dr. Johnson, a request was made when we sent out an agenda to specify whether or not the complaint is an individual complaint or a complaint against the county, just to sort of make sure that's clarified so that counties can know, okay, I don't need to attend. It may say, for instance, Chatham County, but Chatham County knows that they don't have to attend because it's not their board. So we could just sort of clarify that in terms of whether or not it's an individual complaint. Well,
Yeah, just if I may interrupt for a second, if you don't mind, Mr. Lindsay.
yeah.
I do remember this discussion, and the issue was that sometimes there's a reference to a county, and that was the venue of the event
And
that
that's what-
happened.
yeah.
But it gave the impression that the county had done something wrong.
Yeah, that's my
And so
point.
we're going to work on to try and correct that.
Yeah, anyways, we can figure out something with that.
Yeah.
Like I said, we can figure out something like that. And I will leave it to you and the discretion of the chair on how you do it, but just if you can figure something out.
Yeah. Thank you for that reminder. That was a good point when it was raised, and well, I appreciate you bringing it up again so that we can continue to work on that. Thank you. Okay, so now we're on to tab 44.
Okay.
2020-293.
All right, the Secretary of State's office received the following complaints during the November 3rd, 2020 general election and January 5th, 2021 general election runoff in Chatham County. So there were a total of 4 different complaints on individuals as it relates to them basically voting and not having the standing to vote. The first one, and this is from an anonymous individual, reports that Danica Rubenstein of Morgantown, West Virginia, owns a home in Savannah, Georgia. The complainant states that she has a full-time job in Morgantown and that they did not believe she met the residency requirement to be eligible to vote in Georgia. Number 2, the complainant reports the Islands Public Library was an early voting location, and they were in violation of the law because they had campaign material inside of the library. Mrs. Weeks advised the library had a focal display case dedicated to, quote, Black Lives Matter, anti-racism, and other overtly partisan statements under the guise of social justice. She states the bookcase has a sign above it stating woke, quote unquote. The third complaint, the complainant, Lori Acetola, reports Russell and Barbara Smart have residency in Ohio and California. She states the Smarts told him they are going to Georgia just to vote in the Senate election, and they have no intention to live in Georgia. And then finally, Totes Legit reports they were comparing election data between North Carolina and Georgia, and they found a voter that might have voted in Georgia and North Carolina during the November 3rd, 2020 general election. and they advised the voter's name is Marcos A. Morales. As it relates to allegation 1, the investigation revealed in reference that Danica Rubenstein and her fiance purchased a home in Savannah, Georgia. She stated she had every intention to move to Georgia. She obtained a driver's license, registered to vote. She applied for several jobs in Savannah, but at this time she has not found employment. She sold her home in West Virginia, moved in with her fiance, and she indicated that as soon as she finds employment, she is moving to Georgia. There's also a question of standing for the complainant, for this complaint, and this allegation was not sustained. As it relates to allegation 2, the woke display and the accompanying books were not in the room where the early voting was being held at the Island Library. The location of the display was outside of the view of the voters. This allegation is not sustained. The third revealed that the Smarts moved to Georgia in their motorhome. They stayed at their granddaughter's residence in Pooler, Georgia. They registered to vote there. Once they purchased a home in Guyton, Georgia, they moved their voter registration to Effingham County. That allegation is not sustained. Allegation 4, Marcos Morales voted in the November 3rd, 2020 general election in North Carolina and Georgia. He requested an absentee ballot from North Carolina. It was mailed to his residence in Albany, Georgia. He mailed the ballot back to North Carolina and it counted. On November 3rd, 2020, Mr. Morales presented himself at a poll in Savannah, Georgia, and he voted again. He voted more than once in the general election. During the interview, he remembered requesting a ballot from North Carolina, but he did not remember voting that ballot. He advised he did not knowingly vote twice after he received multiple ballots from Georgia and North Carolina. He was informed that they were probably applications, and then he advised he might have voted a real ballot on October 20th, 2020, but it was his first time and he wasn't sure. And he ultimately said he thought he was requesting a ballot from North Carolina. So based on that, there's evidence to suggest that Marcos Morales violated OCGA 21-2-572, repeat voting in the same primary or election.
Member Gazelle?
I believe we received a letter from Mr. Morales that he had asked if it could be read into the record.
That's a unanimous consent request. Are there any objections? Without objection, so ordered. Who wants to read?
I've got it.
Member
up on my
Gazelle
phone.
gets
I
volunteered.
remembered it, so. This is from Mr. Morales, who was not able to be here. Thank you for the opportunity to explain myself on this situation. To initially start, I want to express that this was an utmost genuine mistake that was done unknowingly. The events started with me requesting a ballot from North Carolina, in which I received shortly after. The mistake that took place was believing that I had received in the mail was an official request form and not the ballot itself. My thought process was the form that arrived would have the selections of how you would want your official ballot to look like, i.e. if I selected Republican personnel, I would receive a Republican ballot, or if I requested Democrat Party, I would have received a Democrat ballot. I understand this thought process seems ignorant, but please understand this was my first time ever voting or ever seeing a ballot. Upon sending in the ballot, what I thought was the official request form, I never received anything in the mail. Due to the short voting period, I decided to go in person to a voting booth in Albany, Georgia. Once this was done, at that point, I ended up voting twice by accident. I only was made aware of this incident when an agent from Georgia contacted me after the voting period. Once again, this was a mistake committed unknowingly, and I will make sure to review voting procedures prior to trying again. Respectfully, Marcos Morales. And he is in the Marines. He is an acting first sergeant of the U.S. Marine Corps.
Wow.
Okay, what's the One thing I'd like to kind of clarify is that Mr. Morales' original complainant is Totes Legit, which I don't believe is an organization. I believe it's just like an internet handle. So I want to go ahead and put Totes Legit on notice that it's the board's inclination that the board is going to take seriously the right to confront your accuser. And so Totes Legit, if they want to file complaints in the future, needs to have a human or an organization recognized by the state to be behind the motion or behind the complaint in order to satisfy the requirement that those that are accused of an offense should have the right to confront their accuser. Now, since the investigation took place and was revealed by the inspector of the Secretary of State, the accuser is actually, in this case, the Secretary of State and not Totes Legit. So I think you do have, if Mr. Morales had been able to come, he would have had the right to confront his accuser, because the accuser would have been the Secretary of State's investigators. So, but I do want to put Totes Legit on notice that in the future, the board is going to probably require, if it's the board's will, require that if you're going to file a complaint against your fellow citizens, you better put your name on it. So just my thought on the topic. But having said that, what is the will of the board? Thoughts, ideas?
I make a motion to refer to the Attorney General.
Okay, there's been, and this is only on Morales, the only one that was sustained, right?
Correct.
Okay, so there's been a motion to refer Mr. Morales to the Attorney General. Is there a second? Okay, no second, so the motion fails for lack of a second. Is there another motion?
I move that we issue a letter of reprimand from the board. I do not want any actions that could jeopardize this young man's professional future within the Marine Corps.
Okay, there's been a motion to issue a letter of reprimand. Is there a second?
A second, but a question.
Okay, there's been a second, so we're ready for discussion.
Did he vote in both Georgia and North Carolina? Or did he just receive ballots?
Voted in both states.
He voted in both states.
He did.
Okay, is there any further discussion?
Yes. Chairman.
Dr. Johnston?
So OCGA 21-572 says repeat voting in the same election is a violation. It doesn't talk about intent. So intent is not considered, and the circumstance is up to the Attorney General to mitigate the allegation.
At the appropriate time, I'm going to move to reconsider.
Well, I'm
Dr.
going
Johnson's
to actually make a ruling from the chair and allow you to withdraw your second if you'd like.
Yeah, I'll withdraw my second.
Okay, the second's withdrawn, so the slate is now clean. We're ready for anybody to make a brand-new motion.
I'd like to move to reconsider Dr. Johnson's motion.
Okay, there's a motion that's been remade to refer to the Attorney General's office. Is there a second?
Second.
No. You've
Oh,
made
it's
the
my
motion.
I'm sorry.
A second.
Okay, so there's a motion and a second. All right, motion to refer to the Attorney General, second. Discussion?
Yeah, I struggle with this because he's in the Marines, and I don't want to, and I respect folks who serve, but the fact that he voted in two different states. I've got two children who serve, and I think they know not to vote in two different states. We'll leave it to the Attorney General to sort of talk with them and figure out what's the best way to deal with this issue.
There's no way we can fully appreciate and recognize those that have risked their lives for the rest of us and put their lives on the line to defend the country. But at the same time, they've got to obey the laws that they defend. So we got kind of a conundrum on that one, don't we? So there's been a motion to refer to the Attorney General, and it's been seconded. There's been discussion. Are we ready to vote? Any further discussion?
Yep.
Okay, we're ready to vote. All those in favor would say aye.
Aye.
All those opposed would say no.
Nay.
Motion carries 2-1. Okay, now we've got tab number 45. SCB 2021-079, voter problem.
Mr. Chairman,
Dr. Johnston.
just a word, if I may, for the record. I have a family full of Marines, and my son that's a Marine would have agreed with me 100%. So,
Duly noted. Duly noted. Okay, we're ready to move on to 45. Tab number 45. The inspectors, the floor is yours.
Okay. The Secretary of State's office opened this investigation after receiving complaints
Okay,
from...
I'm sorry. I thought we were going to interrupt you, but I interrupted you inadvertently. I'm sorry. So please begin again. I'm sorry, my error.
The Secretary of State's office opened this investigation after receiving complaints from Gwinnett County voter Tyler Alvin Morris reporting that someone illegally used his identity to cast a vote for the November 2020 general election because he went to a poll during the advanced voting period on or about October 28, 2020 to vote. While there, poll officials informed him that he had already voted, when in fact he had not. So upon further investigation, on February 21st, 2021, Christy Royston, then election supervisor of the Gwinnett County Board of Elections and Registration, conducted a follow-up inquiry and advised the Secretary of State's office that the advanced polling site incorrectly marked advanced in-person applicant Tyler Rhyne, R-H-Y-N-E Morris, as Tyler Alvin Morris, and gave the credit to Tyler Alvin Morris. Royston provided a copy of the voter registration and elections application for official advanced in-person voting completed by Tyler Rhyne Morris on October 14, 2020, which showed poll worker Susan Sharp printed a bar-coded label from the Georgia voter registration system, better known as ENET, in the name of Tyler Alvin Morris, and affixed the label to the AIP application for Tyler Rhyne Morris. Royston further advised that Tyler Alvin Morris was issued a provisional ballot on November 3rd, 2020. However, the provisional ballot was not counted, though ENET showed he received voting credit for an AIP ballot he did not cast. On March 24, 2021, a review by then investigator Humes of Tyler Alvin Morris's voter history in the Georgia voter registration system confirmed that Tyler Alvin Morris was erroneously given credit for Tyler Rhyne Morris's vote cast on October 14, 2020. On March 29, 2021, investigator Humes obtained and reviewed a copy of the ballot style for Tyler Rhyne Morris and Tyler Alvin Morris. Despite the fact that Tyler Rhyne Morris is to receive credit for voting, the ballots reveal that Tyler Rhyne Morris voted out of district, and as a result of the error, Tyler Rhyne Morris was not afforded the opportunity to vote for some local candidates that would have appeared on his correct ballot. So ultimately, the investigative findings, the investigation revealed that a Gwinnett County voter properly completed an application for official advanced in-person voting to cast a vote in the November 2020 general election. The voter also presented a valid identification with his application that was accepted. However, the poll worker at the advanced voting site subsequently selected the name of a different voter with a similar name and went through the process. So ultimately, there is evidence to suggest that poll worker Susan Sharp violated SEB Rule 183-1-12-.11 sub 2 sub A that says when a person presents himself or herself at the polling place for the purpose of voting during the time during which the polls are open for voting, the person shall complete a voter certificate and submit it to the poll officer. The voter certificate may be an electronic or paper record. The poll officer shall verify the identity of the person and that the person is a registered voter of the precinct, and if so, shall approve the voter certificate and enter an appropriate designation on the elector list for the precinct reflecting that the voter has voted in the primary election or runoff being conducted. The voter's name shall then be entered onto the appropriate list of voters.
Okay, questions for the investigators by the board? Okay, is anybody here from Gwinnett County? If you press your button, there you are, I see you.
I pressed my button.
There you go, we should have a good microphone for you.
I think I have a good microphone.
All right.
So, Mr. Chairman, members of the board, thank you for the opportunity to address the board on this matter. As I understand it, the named respondents are Ms. Sharp, Christy Royston, former election supervisor, and the Gwinnett County Board of Registration Elections. If the investigator would confirm that for me before I begin my comments to the board, that would be helpful. Certainly, Ms. Royston's was sent correspondence to Gwinnett as well as the board. I cannot speak for Ms. Sharp. I don't know if she was noticed. I would say that. But there's three things I want to talk about because these are tough facts. Because at the end of the day, 2 voters were disenfranchised. And that's not something that I am here on behalf of the board to deny. I'm accompanied by the current election supervisor, Zach Manifold. Ms. Royston left the county in March of 2021. This matter arises from the November 2020 election, and it was first heard by this board in September of 2021. And I reviewed the transcript, and at that time, it was my understanding that, looking back at the transcript, a critical document that we thought was relevant for the board to have was not available, and that turned out to be the advanced in-person application that shows the erroneous sticker on the wrong application. So we have Tyler R. Morris of Buford turns up to vote during AIP, and the poll worker would say that she scanned the driver's license. Whatever happened there, certainly the wrong voter was identified. That's the bottom line, and we're not here to run away from that fact. But I am grateful that we have identified the document that tells the truth about what happened. This was not voter fraud. This was a human failure, a series of human errors and subsequent human failures, and I'll speak to all 3 of those. I think it might be helpful if you haven't seen it for me to give you a copy of the advanced in-person application with the sticker on it, because I have a copy of that if that would be helpful.
Yeah, absolutely, absolutely. I think this might be the first time we've seen you in person. We had heard you over the phone many times. So welcome. Good to see you.
Thank you. Thank you.
I'm going to start first by acknowledging that there was a failure here. 2 voters were disenfranchised. That failure is ours. It sits squarely on the shoulders of the Gwinnett County election officials. I had the opportunity to attend Gavrio last week, and I heard Chairman Mashburn speak, and I made a note of something that he said. He said, rigorous attention to the mundane can prevent problems. And that's going to sit with me. And I was glad that I was there with several members of the team, from Gwinnett County election officials team, for us to hear reiterated over and over again the importance of what seems mundane, super important every time. The mundane, that's where the details, the devil's in the details, but we're called upon to get it right. In Gwinnett County in 2020, we had approximately 416,000 voters cast ballots. 217 of those voted during AIP, 73,000 voted on election day, and 124,000 voted on absentee ballot. In 2022, we had 172,000 people voted, over 100,000 voted on election day, and 20,000 people voted absentee. So we're in the business of, in our county, serving large numbers of people, hundreds of thousands of voters every cycle, but that doesn't matter, because in relation to this voter, we failed. And that's something we have to take responsibility for. Gwinnett County has a standard of excellence that it holds itself to. We fell short of that. And I can only offer an apology on behalf of the board. I think it's appropriate. We didn't serve the voters well. So the first error was when the poll worker pulled the wrong voter, whether that was in scanning the driver's license, identified the voter incorrectly, pulled the wrong sticker, as you can clearly see. Tyler A sticker was applied to the advance in-person application for Tyler R. That was the first mistake. But there were points in the process later on that could have avoided the disenfranchisement of the voter. Because there was an opportunity, Mr. Tyler A, when he then attempted to vote, he was given a provisional ballot, and I want to come back to that issue, but he was given a provisional ballot. There's no specific category that addresses a voter in that situation. So we know about out of precinct, we know about additional documents required, but a voter that gets to the polls and is told, oh, our records show you've already voted, there's no specific category statutorily authorized, but that was a fail-safe measure that was taken. And it would have worked if, when we were reviewing the provisional ballots during the validation process between election day and certification, if we had pulled the documentation, there was a form that was generated when Mr. Tyler A voted that specifically said this voter is authorized to receive an absentee ballot because he contends that he didn't vote. But when we pulled the provisional ballots, when we reviewed the documentation, if we had gone back to pull Tyler R's application, the story would have been revealed and we wouldn't be here. So rigorous attention to the mundane makes all the difference. So again, human error compounded by subsequent human failure. So it becomes important then that I address the second topic. What steps, because it's critical to us to get it right, because we want to get it right. The voters deserve that. What steps have we taken subsequent to November of 2010 to prevent this from happening? So there's been a technological advance that's going to help us, and I want to start with the statewide deployment of poll pads. We can't claim responsibility for it, but we know it can save us. It can save us. The way the poll pad works is that the voter goes to the election site. Well, let's start with AIP, advanced in-person voting, early voting, whatever you want to describe it. And so when the voter checks in, the vast majority of people in the state use a driver's license, or that gets scanned, pulls back the voter from JARVIS. That's how it's supposed to work. Alternatively, if the voter produces some other form of identification, the poll worker would identify the voter. They're on the screen, this little screen that sits on the desk. The poll worker finds it, they turn the screen around, and so the voter now is actively engaged in the process of confirming, I am Melanie Wilson of Peachtree City. That's me, and I sign that form. So then I'm actively engaged in the process. The mistake that occurred in 2020 couldn't occur in the future that we're about to inhabit beginning, as we start our election cycle in January. So even though we won't take credit for that as a step that we've taken, it's technology, it's the deployment of technology that we intend to take full advantage of. Because what we're going to do in Gwinnett County, we're going to have printers at the AIP location, so that certificate's going to print out. So it gets signed by the voter. The voter can confirm, yes, that's me. The certificate is generated by the poll pad, we'll print it out, and then we'll have an audit process that matches the voter certificate with the correct advance in person application. So that document there, in the future, not so distant, would have attached to it the correct voter certificate signed by the voter. So we're going to maximize the utility of the poll pad. The other two measures that I can speak to that we've done in response to this incident, there is an hourly count at advance in person polling locations of the voters we count the number of applications that have come in, the advanced in-person application, to see, okay, here we are every hour, how many people have come in, how many people have voted. And there's going to be a review on site to look at the fields, go back and make sure that the certificate that I just mentioned matches. That's going to happen at the AIP location. So additionally, that last fail-safe measure that I spoke about, when we had the opportunity to check the paperwork before the provisional ballot validation process, we've added a step to the provisional ballot review worksheet that mandates, requires that any paperwork that speaks to the complaint or the underlying reason for why the provisional ballot was cast. And here, it would have been cast because Mr. Morris said, well, I'm voting here, I've been told I've already voted, but I haven't. It would force the poll worker who's working on that provisional ballot review to go put their hands on the application, to double check the story, to double check that a voter like Mr. Morris isn't being disenfranchised. So we think between the deployment of the poll pads, an improved review process at the AIP location, and this improvement to the provisional ballot research that happens before they're validated, that those three measures will minimize the risk of this happening. The challenge that we have is we have to live with human error, but it shouldn't disenfranchise a voter. So there should be layers in place to prevent a voter from being disenfranchised. I think these are hard facts, and what I would ask the board to consider doing here is certainly, well, I want to talk about training. Because when we looked at this issue, we feel comfortable and confident that we have good training in effect, a good training process, good manuals, good documentation, and I can certainly speak to the individual poll worker here. We checked our records. She served in 2018, 2020. She served in May of 2022, but hasn't served since then. But we know that in this particular situation, training was not the issue. But of course, in training, we constantly emphasize the importance of checking the details. Rigorous attention to the mundane can prevent big problems. And so in relation to this situation, in the ideal world, if I could leave here with a letter of instruction, that would be great. But I don't feel able to ask that of the board. I think I'm asking for it on behalf for Ms. Royston, because she is no longer in the elections business. I don't see the point of a sanction against her for something like this. But I think that we've offered an explanation for the failure, not a justification for it. One of the things that I'm grateful for is that we were able to put our hands on the documentation that tells the story, because I think in an era of heightened scrutiny by active, engaged citizens around election administration, our ability to find documents to tell the story, that's worth something. And so as you deliberate, I'd ask you to take all those facts into consideration. I don't know if you have any questions for me or any questions for Mr. Manifold, but I think that's the extent of my comments. Thank you.
Thank you so much. I have a question.
Dr. Johnston has the floor.
Is the sticker placed on the application before the voter signs or after the voter signs?
After the voter signs.
Okay. So obviously the sticker's wrong.
It is.
And the address is wrong.
Well, the address belongs to Tyler A. Morris.
Right.
But the address does not belong to Tyler R. Morris, who presented
Right.
himself to vote. Absolutely.
Right. So who checks between the two? I mean, who checks that the address on the sticker, the information on the sticker is the same that was filled out by the
So
voter?
the poll worker scans the driver's license.
Right.
That's typically the form of ID that's presented. This situation occurred while we were using the ENET system. And
So it's
so ENET generates the sticker, and the sticker is applied to the advanced in-person application. It's supposed to be checked, Dr. Johnston. There's no hiding from the fact that it's supposed to be checked.
Dr. Johnston, still at the floor? You're satisfied? Okay. Member Gazelle?
At the appropriate time, I'd like to make a motion.
Okay.
I would move that we dismiss Christy Royston from the case and refer the county and Ms. Sharp to the Attorney General's office with a request that they work closely with the county and taken into context the fact that they have taken tremendous steps to prevent this from recurring.
Okay, there's been a motion. Is there a second?
Yeah, I'll second it. And usually, as you've seen before, if I may, Mr. Chairman, we usually try to go with a letter of reprimand or letter of instruction, but given the fact that 2 voters were disenfranchised, I think we have to take that a little more seriously. And but I do recognize the work that you've done to rectify that. And Zach, you got a good lawyer here, and you're a good and supervisor. I just simply ask that you work with the Attorney General's office to work out a consent order.
Yes, sir.
And let's make sure it doesn't happen again.
Yes, sir.
Thank you. But that's the reason why I'm going at extra length rather than simply a letter of reprimand, is that 2 voters were disenfranchised.
Okay. Let me make sure I've got the motion accurately stated. There's a motion to dismiss Christy Royston.
Yes.
Okay. Motion to dismiss Christy Royston and a motion to refer the county to the Attorney General. And Dr. Johnston would like to have discussion, I believe, if I'm reading the room correctly.
I would have asked for a letter of instruction in this situation. I think the equipment has changed, and they certainly recognize the error. I suspect in a county as large as Gwinnett, inadvertent, totally unintentional errors can be made, especially with people with similar names, with very similar names. But you're exactly right, attention to detail. It's hurry up slowly, which means, you want to be efficient and process voters in a timely way, but not make mistakes. There's probably an acceptable error rate in an election if we were, if we looked into it. Not that, we want 100% perfect, but it's looking at the big problems or the patterns that I think really need to be sent to the Attorney General.
Okay, there's a motion on the floor that's been seconded. Any further discussion? Okay, so there's a motion to dismiss Christy Royston and a motion to refer the county to the Attorney General with due consideration of the excellent presentation that the county put on with regard to what happened and what they've done to prevent it from happening in the future. And we request that that be taken into consideration. Any further discussion? All those in favor would say aye.
Aye.
All those opposed would say no.
No.
2-1. Motion carries. Now we move to
Tab 46.
46. Possible absentee ballot fraud. Everybody agree? 2021-104. That was an excellent presentation, Counselor. Well done. Y'all are excused. Unless you got another one, I don't think you do. Y'all are excused. The investigator has the floor.
Former Chief Investigator Francis Watson reports that during the November 3rd, 2020 general election, an absentee ballot was requested in the name of Mark Kendall Johns, and he requested it to be mailed to Kannapolis, North Carolina. The ballot was returned to the Chatham County Elections Office, and the signature of the voter was verified, and the ballot was counted. She later interviewed Mr. Johns, and he denied requesting and voting an absentee ballot from Georgia. So from there, ultimately, the investigation revealed that Mr. Johns was listed as an active voter on the Chatham County voter list. An application for an official absentee ballot was mailed to Mr. Johns during the November 3rd, 2020 general election. Mr. John no longer resided in Georgia, but he filled out the application anyway. He was found eligible to receive the ballot, and he requested it to be mailed to his residence in North Carolina. Mr. Johns voted the ballot, and he mailed it back to the Chatham County Elections Office, and it was counted. Mr. John was contacted by former Chief Investigator Watson about an allegation that he no longer resided in Georgia when he voted the absentee ballot. Mr. John submitted a statement that said, quote, "I did not vote in Georgia. If a vote was cast in my name, then it was an error or possibly fraudulent. Please disregard. Thank you, Mark Johns." End quote. Investigators interviewed Mr. Johns, and he reported he did not remember voting an absentee ballot from Georgia. Mr. Johns stated he definitely voted, and he thought he voted in North Carolina. Investigators informed Mr. Johns he was not registered to vote in North Carolina, that he was a registered voter in South Carolina and Georgia. Investigator advised Mr. John the statement he sent to former Chief Investigator Francis Watson that if a vote was cast in my name, then it was an error or possibly fraudulent. That investigator asked Mr. John what he meant by error, and he said he was peppered with a lot of requests to register to vote. He said he thought he was filling out something from North Carolina. He advised he might have gotten something from Georgia, and he certainly did not remember going out and asking for anything from Georgia. Mr. Johns stated he could have done it, and that is why he says it's an error, because if he did it, he did not mean to. So ultimately, he hasn't lived in Georgia since 2018, and he voted. So based on that, there is evidence to suggest Mark Kendall Johns violated OCGA 21-2-573 absentee voting by an unqualified elector during the November 3rd, 2020 general election.
Is Mr. Johns here? Mr. Johns? Mark Kendall Johns? Okay, questions for the investigator? Questions from the board for the investigator? Okay.
This is starting to, a comment if I may, starting to sound like the old three-level defense to a dog bite case. Not my dog. My dog didn't bite. You bit my dog first. At the appropriate time, I'll make a motion. I mean, he came up with some good stories here.
I believe this is the appropriate time, if you have a motion.
Move to refer to the Attorney General.
Been a motion to refer to the Attorney General. Is there a second?
Second.
It's been seconded by Dr. Johnston. A motion and second. Is there any discussion? No discussion. We're ready to vote. All those in favor would say aye.
Aye.
All those opposed would say no. Motion carries 3-0. Refer to the Attorney General. And the last case we have for today's session is qualifying in residency in Grady County. Anybody here from Grady County? You get the award for the most patient? Okay. Nobody here from Grady County, so the floor belongs to the investigators.
On September 13, 2021, Investigator Miller was forwarded a complaint alleging Jeremiah Horn qualified as a District 4 City Council candidate for Cairo, the city of Cairo, while residing outside the city limits. Mr. Horn reportedly resides at 1911 Georgia Highway 93 North in Cairo, yet he qualified for the District 4 City Council race, declaring 745 U.S. Highway East in Cairo as his residence. On August 25th, 2021, an individual filed a challenge to the qualification of Horn based upon residency requirements. He mentioned Mr. Horn having signed his notice of candidacy, an affidavit of his legal residence being 745 Highway 84 East in Cairo, and being a resident there for 1 year. It was discovered this address was zoned as commercial, and it's the location of XPT Battery Company, which is his company. A hearing was held concerning Horn's residency, and the hearing transcript, along with the qualifying documents, were obtained from the city clerk in Cairo, Dana Barfield. Based on circumstances surrounding Horn's residency issues, it was determined his actual residence is located outside the Cairo city limits and not the business address inside the city of Cairo. Mr. Horn was disqualified from the Cairo District 4 City Council race, and the conclusion was Mr. Horn resided at 1911 State Highway 93 North in Cairo, which is outside the city limits. On February 10, 2022, Mr. Horn responded and addressed the residency issue in an email statement. Those statements were, in 2011, he moved into the city of Cairo, where he also opened a business. He registered to vote at the business address of 745 U.S. Highway 84 East. His first time voting in the city was the 2012 presidential election. A few years later, while building, he moved family in with his parents in the county. He listed his business address as his personal address on all accounts since 2011. He preferred to receive his mail at his business. In 2014, he moved into the home located in the county. In 2019, his office moved down the street into a different district. In June 2020, he renewed his driver's license, registering to vote with documents listing his business address. He does not own, lease, nor receive mail at his nightly resting place, and he has no documents associated with his current residential address. Ultimately, he was disqualified based on his own admission surrounding his residency. On Wednesday, February 23rd, 2022, it was discovered Supervisor Archie investigated a separate case SCB 2021-182, City of Cairo problems at polling place, and had gathered facts and evidence to cite Mr. Horn, along with his wife, for violating OCGA 21-561 false registration, and that in 2020, they both registered to vote in Grady County using the address of their business, XPT Battery Company, located at 745 US Highway 84 in Cairo. The Horns did not reside at the business, but they permanently reside at the location 1911 Highway 93 North in Cairo. So ultimately, determined that there is evidence to suggest that Jeremiah Horn violated OCGA 21-2-565, making a false statement in connection with the filing for his notice of candidacy, and that on August 18th, he filed his notice listing his residence address at 745 US Highway 84 East in Cairo, Georgia, which was the address of his business, which is the XPT Battery Company.
Questions for the investigators from the board? Question for the investigator from the board?
Just one quick. In Georgia, Houston is pronounced Houston. Milan is pronounced Milan. And only in the state of Georgia could we pronounce Cairo as Cairo.
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 I'm from Florida by way of Wisconsin, so I've been here 3 years. So
You're my great investigator. Don't get me wrong. I'm just trying to help you.
Is Mr. Horn here? Mr. Horn? Mr. Horn? Mr. Horn here? Well, just for people listening out there in the public, one of the questions that we always get is, why does it matter if you use a business address or a residence address, and the law requires the residence address? And the reason why the law requires the residence address is you're to be voting for the local officials who represent the area where you live. And your business might very well be in a completely different commissioner district, for example, and you're voting on somebody else's commissioner and not voting on your own commissioner. So that's why it matters. And so, one of the questions that you always get is, why does it matter? And that's why, as we want you voting for the officials that are closest to you. Questions, comments from the board? Thoughts from the board?
Well, I'm thrilled that you said that, because why does it matter? If it matters where you live to run for a contest, then certainly it should matter where you live to vote.
Exactly.
So that a commercial address would not be an acceptable residence address. But I think we have some inconsistencies in our counties as far as how they treat voter registration addresses. So I'm delighted that you brought that up, because we should be consistent and uniform in how we deal with with candidates for office, and how we deal with registration of electors.
And if I might append to my remarks, one of the issues that we've come up with is there were people that used addresses because somebody wanted to kill them. And so they're like, I don't want to put my real address because somebody's trying to kill me. But in this case, I'm bothered because it just says it's more convenient. And so you shouldn't be voting for other people's elected officials just because something's convenient. So that's what bothers me on this one.
Certainly, and I think the rare situation of somebody's trying to kill me cannot possibly apply to the many, many people that are registered to vote at non-residential addresses.
And the board has publicized, with the great help of the Atlanta Journal-Constitution, the AJC helped get out the word that there is a SAFE program where you can register and vote and participate if you're in a situation that's dangerous. So thanks to the Atlanta Journal for getting that out and getting that information out. We appreciate it.
That's greatly appreciated.
Thoughts from the board? Questions from the board? How do you want to treat this?
Motion to refer to the Attorney General.
Been a motion to refer to the Attorney General. Is there a second?
Second?
It's been motioned and seconded, moved and seconded. All in discussion? All those in favor would say aye.
Aye.
All those would, what? Okay, all those opposed would say no. Okay, that concludes today's agenda. We will stand in recess until tomorrow morning. Oops,
Excuse me.
we will, hang on.
I don't know what we tabled, tab 28.
It is continued because it needs Michael Barnes.
Okay, just wanted to make sure.
Okay. Okay, we got that handled. So we will now stand in recess until 9:30 a.m. tomorrow morning in this same room. And since we are in recess, there's no need for a motion.